como vocês se sentem à vontade.
Acho que todo mundo que está participando é bilíngue. Quer dizer, nos painéis, né, que daí vocês vão estar interessando para algumas nativas aí de outros
Já
idiomas.
estamos ao vivo, professora Juliana. Pode passar as orientações, mas assim, ao vivo a gente passa a orientação ao vivo mesmo, não tem problema.
Good morning, everyone. Let's begin our event now. I'm very happy to be part of this webinar, which also marks the launch of the association's first international book. I would like to thank you all for being here today. This book brings some of the most recent discussions in antitrust and regulation law, with 12 articles and 24 authors from 6 countries. To introduce myself, I'm Midian Lira, a lawyer at Pereira Neto Macedo Advogados, and specialized in antitrust and regulation law, and academic director of Women in Antitrust. It's a pleasure to be here opening this webinar with Vicente, Juliana, Bruno Almeida. And now I invite Professor Juliana, Vicente, Bruno to join us. Juliana is a former Attorney General of the Brazilian Antitrust Authority, and Professor of Economic Law at the University of São Paulo. She was postdoctoral fellow as a visiting scholar at Georgetown University. She is a regional director of the Ascola and founder of the Women in Antitrust. Vicente is a professor at law at Mackenzie, PhD in philosophy and general theory of law of the University of São Paulo, visiting research at the Max Planck Institute for Innovation and Competition, Master in Political and Economic Law, Bachelor of Law from the Mackenzie University, Regional Director for Brazil and member of Ascola and partner at Vicente Bagnoli Advogados. Chaplain Reverend Bruno Almeida. Now I invite to join us. Thank you so much.
Bom dia a todos. Good morning, everyone. I do a mix because the opening session, Professor Juliana and Midian, we do half in Portuguese, half in English. And before I give some words and transfer to Professor Juliana, I'd like to invite Reverend Bruno Almeida Borges to do the devotional. We are very happy to join this conference organized by Ascola and Women in Antitrust. The Ascola, which together with Professor Juliana, we are I can say the heads here in Brazil, the chapter of Brazil of Ascola. But all the conference is hosted by Mackenzie Presbyterian University. So this is it's considered an official event of Mackenzie, and all official events we have the opening with the words of our Reverend. So once again, I'd like to invite Reverend Bruno Almeida Borges to give his words, to introduce the words of God, to shine our day and to bring us a very fruitful work. So now I will change a little to Portuguese. As I said, Mackenzie é uma universidade confessional, é a Universidade Presbiteriana Mackenzie, para aqueles que não são de São Paulo e não conhecem. E todos os eventos oficiais da Universidade Presbiteriana Mackenzie se iniciam com o devocional que é feito pelo reverendo. Hoje é um evento da Ascola, Academic Society for Competition Law, juntamente com Women in Antitrust, mas sediado, ia falar hosted, né? Sediado, promovido aqui pela Universidade Mackenzie. Como é um evento oficial, então eu já passo a palavra ao nosso reverendo Bruno Almeida Borges, para que faça suas palavras, traga as palavras de Deus, que certamente abrilhantarão todos os nossos trabalhos nesse dia.
Bom dia a todos, é uma alegria poder falar com vocês, a todos os professores, os estudantes também. Espero que vocês tenham um dia muito produtivo. Para esse momento introdutório, eu vou fazer a devocional, eu vou fazer na nossa língua materna mesmo, tá? Para que possamos ter um contato. Quando a gente escuta algo na nossa própria língua materna, parece que toca mais profundamente no nosso coração. Então, o texto que eu separei para nossa manhã está lá no livro do profeta Malaquias, um livro ainda do Antigo Testamento, Malaquias 2, capítulo 4, perdão, versículo 2. O texto, ele nos diz assim: mas para vós outros que temeis o meu nome, nascerá o sol da justiça, trazendo salvação nas suas asas. A ideia de pessoas se unindo para fazerem acordos injustos, de maneira oculta, nos dá um pouco de sentimento de impotência. Nós sabemos que esse tipo de coisa acontece e, infelizmente, vai continuar existindo enquanto nós estivermos aqui desse lado da vida. Nós não temos como tomar ciência de todos os atos ilegais que acontecem às ocultas. E certamente nós devemos ser gratos a Deus pela vida dos operadores do direito que visam refrear esse tipo de atos ilegais. Mas o fato é que alguns desses acordos, eles irão acontecer e nós nunca teremos como tomar ciência deles. O que pode ser feito hoje, por meio dos operadores de direito, daqueles que cuidam das leis da nação, é refrear, de alguma forma, esses atos ilegais que acontece, mas infelizmente nós sabemos da limitação que nós temos e não conseguimos extingui-los por completo. No texto que eu acabei de ler, há um anúncio de um dia onde as injustiças praticadas serão extintas entre nós. Aqui, o autor, o profeta Malaquias, está vivendo em um período onde ele via constantes atos de injustiça e que ele estava buscando algum tipo de esperança para o coração dele. E é diante disso, então, que ele apresenta uma mensagem da parte de Deus e ele fala diretamente para aqueles que são tementes a Deus. O texto diz: mas a vós outros que temeis o meu nome, nascerá o sol da justiça. Exatamente sobre o que quem é esse temente a Deus? Aqui a ideia de temor a Deus é a ideia de um amor respeitoso. Veja, a relação que nós podemos ter com Deus, ela é marcada basicamente por duas características. Primeiro, nós devemos saber que Ele é o Criador, governador e o que sustenta todas as coisas. E isso deve gerar em nós um senso de temor, de respeito a Ele. Mas, por outro lado, esse mesmo Deus nos chama a termos uma relação próxima com Ele, como de filhos com o Pai. Isso nos traz uma certa intimidade e aproximação com Ele. Então, a ideia de temer ao Senhor é esse que tem essa relação com Deus, de respeito, mas, ao mesmo tempo, uma relação de amor em relação a Ele. E para esses que temem a Deus é prometido algo: o nascer do sol da justiça. A imagem do sol é muito, muito vívida para nós. Nos aponta para aquilo que, quando chega, tira o lugar de onde estamos das trevas. Algo que está oculto, algo que está em trevas. E aí, então, vem o sol trazendo a sua claridade, trazendo luz para o ambiente onde nós estamos. E o que está sendo anunciado aqui, por meio desse texto, é um dia onde todos os atos injustos, visto que é o sol da justiça que está nascendo, eles vão deixar de ser ocultos, pois o sol da justiça nasceu. E esse sol aparece aqui, segundo o texto, trazendo salvação nas suas asas. É o mesmo que libertação, é o mesmo que uma liberdade daquilo que está oculto. E, queridos, de maneira bem clara, o que o texto está anunciando aqui é a ideia da segunda vinda de Cristo como sendo um dia que vai chegar para trazer clareza a tudo aquilo de errado que foi feito, tudo aquilo de oculto que foi feito. Jesus, ele é descrito como o rei, como o juiz em toda a leitura das Sagradas Escrituras, nós conseguimos encontrar a ideia da segunda vinda de Cristo como um dia diferente de todos os outros, em que ele vem para poder exercer a justiça, até mesmo sobre aquelas injustiças que que estão ocultas, ele vai trazer à luz, porque ele é o sol da justiça. Mas quais lições, de maneira bem objetiva, esse texto pode trazer para nós? Primeiro, aqui é uma mensagem de expectativa para o nosso coração, do estabelecimento da plena justiça. Todos nós que tomamos conhecimento de eventos injustos, nós almejamos pelo pleno estabelecimento da justiça, especialmente quando tratamos de acordos ilegais, coisas ocultas que as pessoas fazem. Nós podemos esperar esse estabelecimento da justiça, porque a promessa que está presente aqui nesse texto é de um momento em que todas as injustiças serão julgadas pelo Supremo Juiz, aquele que nada tem oculto diante dos seus olhos. Mas essa também é uma mensagem de autoexame para nós, porque tantas vezes nós deixamos de olhar para nós mesmos, para os nossos próprios corações, e vermos os atos errados que nós mesmos cometemos, seja de falta de cuidado com o próximo, falta de amor ao próximo, seja também no nosso próprio coração, quando nós temos pensamentos que são bem equivocados. E nós estamos diante de um texto que fala de um Deus que sonda absolutamente tudo, até mesmo o nosso coração. Nada fica oculto diante dos olhos dele. Mas também esse texto é um texto de esperança para nós. Primeiro porque esse mesmo livro, o mesmo livro da Bíblia que fala sobre o nascer do sol da justiça, fala de um Deus que perdoa, fala de um Deus que tem misericórdia e que nos recebe de maneira bondosa na pessoa de seu Filho, o Senhor Jesus Cristo. Mas também esse texto nos traz uma mensagem de esperança, porque nós podemos aguardar que o sol da justiça um dia vai raiar, onde poderemos viver em um mundo plenamente justo, onde não haverá mais tramas ocultas, coisas ilegais que são feitas, porque o sol da justiça vai brilhar. E isso pode trazer esperança no nosso coração. Que enquanto vivemos nesse mundo quebrado, onde as injustiças, os erros são tão presentes, que o nosso coração possa encontrar alegria na expectativa de um dia em que o sol da justiça vai raiar, em que o bom Deus haverá de estabelecer justiça plena no mundo em que viveremos, porque ele será restaurado por meio da pessoa bendita do Filho de Deus, o Senhor Jesus Cristo. Meus queridos, que Deus abençoe grandemente o evento de vocês, que essa mensagem traga esperança para o coração de vocês. Um ótimo dia.
Estava com o microfone fechado. Muito obrigado, reverendo Bruno Almeida Borges. Palavras que abençoam a nossa jornada no dia de hoje. E é interessante, a palavra de Deus, né, interpretado para compreender o dia a dia, né, a vida terrena. E o senhor falando me lembrou muito os cartéis. Os cartéis, acordos ocultos, daqueles que, ao invés de competirem no mercado de forma sadia, de forma honesta, se unem para aumentar preço, burlar as licitações. Então, veja como a gente consegue aplicar sempre a palavra de Deus. Evidente, o direito da concorrência não é a lei divina, não é a lei de Deus, mas é a lei aplicada pelos homens, de certa forma, para ajustar esses desvios de comportamentos que nós temos aqui na Terra. Então, muito obrigado, reverendo Bruno Almeida, por trazer as palavras que abençoam a nossa jornada no dia de hoje. E eu já passo a palavra, então, à professora Juliana Domingues. Professora Juliana Domingues, I'm delighted with the event that we have today. We have 3 panels, and I'm very excited about that. The panel 1, changes brought by digital platforms and antitrust challenges. Panel 2, a cross-disciplinary approach to antitrust law. And panel 3, merger review involving digital platforms, case analysis. What we can expect about that? Agora você está muda. Muda? You are muted. Está muda. Agora sim.
Trying to fix it.
Pronto.
Now?
Yes.
Yes, okay.
There you are.
Good morning. and good evening, because we have people from different places around, and I'm very glad about it. I would like to thank you, Median, for this amazing organization. MIDI is doing a great job inside our Women in Antitrust, and I think it's very special to have again this meeting with Mackenzie, Ascola. I would like to thank you, Reverendo Bruno, for your words. And of course, I'd like to thank all the writers and everybody that was here involved in this organization. We have a great team inside WIA. And in fact, what I'm doing here is just connecting our network with Ascola and with academia. And this is something that I really like to do. Last year, we didn't have the chance to have this meeting that I think it's already traditional. The first one was inside Mackenzie and was very different for us because it was the first time we could share the ideas from the Women in Antitrust group with academics inside the university. And Ascola has this kind of target to make academia closer to the ideas from the antitrust and the ideas that we develop to enhance and also to achieve the goals of antitrust. So I'm going to switch a little bit into Portuguese because as I could see, our audience now in this beginning is much more Portuguese speakers. But of course, I will follow the rest of the discussions. And as we have people from different countries, women that they are very knowing in their countries, and also they were involved in this book. I'm going to just switch a little bit in Portuguese to say bom dia para todos e todas. Agradecer a presença de todos que nos acompanham, mas agradecer especialmente a organização desse evento pela Rede das Mulheres do Antitrust, em nome da mídia que está aqui, a mídia que fez um trabalho maravilhoso, que tem sido uma porta-voz desse projeto. Hoje é um dia muito especial para nós, porque esse é um projeto que já se iniciou há 4 anos, né, que é trazer para a academia, para trazer para dentro da escola esses papers que são desenvolvidos por mulheres do Antitrust, disseminar esse conhecimento das mulheres para que elas possam ocupar mais espaços, e isso muitas vezes pode não parecer para muitos relevante, mas os dados que nós temos até hoje atualizados, por exemplo, de citações de produções acadêmicas no Supremo Tribunal Federal, em sua grande maioria são de acadêmicos do sexo masculino, o que não se explica muito bem, considerando que pelo menos metade das salas de aula, quando entramos, não é, professor Vicente, é composto também por mulheres. Então, dar essa visibilidade para essas atividades é algo super importante, é algo que, enquanto estive no CAD, também procurei fazer, e eu acho que é uma missão também da rede, junto com a academia e junto com a escola, que também tem uma preocupação com a diversidade não só de gênero, mas com a diversidade de ideias. Então, hoje nós vamos ter um pouquinho disso, com a presença das nossas palestrantes. Eu gostaria de agradecer à rede por também acreditar nesse projeto. Esse livro foi um livro organizado por muitas mulheres da rede, então, por isso que eu digo que o meu papel é um papel absolutamente simbólico de conectar, né, esse projeto com a escola e com agora o Mackenzie, que nos dá esse espaço, que já está aí fazendo o streaming dessa apresentação. Então, agradecer ao Mackenzie em nome das 2 pessoas que representam essa instituição nesse momento, não só o professor Vicente, mas o reverendo Bruno, agradecendo também pelas palavras gentis para o início de evento e o início de dia, que certamente será abençoado para todos nós e que vamos aprender muito, porque as ideias são excelentes, os papers foram todos analisados em double blind review, que significa que realmente são materiais que foram analisados de uma forma anonimizada, né, garantindo também a qualidade e também o fato de que nós tivemos aí uma preocupação muito grande em trazer essa diversidade regional para essa publicação, que é uma publicação internacional. E que bom que tivemos brasileiras também escolhidas. Então, sem mais delongas, I'm glad that I could also speak in Portuguese, and I will give the floor to Midian again. Then we have the following minutes to also inform you about the next steps from this great meeting. Thank you so much.
Thank you very much, Juliana. Vicente?
Midian, depois que você falar, eu queria só mandar aviso aqui.
Great. Thank you very much, Juliana, Bruno. I would like to give special thanks to Priscila Brolio, Silvio Fagá, Juliana Domingues, Leda Batista, Professor Vicente Bagnoli, to support of our event. Yeah. Now I invite Leda Batista, Professor Vicente.
Sim, só pelo lado do Mackenzie, from Mackenzie side, I'd like to thank Mackenzie Law School, the Center Mackenzie of Economic Freedom, and the Economic and Business School of Mackenzie, and also I would say in Portuguese, o Núcleo de Produção de Desenvolvimento Acadêmico that is broadcasting this conference, and I'd like to thanks two persons, Jonathan from the Mackenzie Center of Economic Freedom, and Lucas from the Secretariat of Mackenzie Law School. They helped us a lot to make it possible. So this is some words, and in Português, os alunos do Mackenzie, durante os painéis, primeiro painel, segundo painel, terceiro painel, mas para o final dos painéis será colocado no chat um link do Forms para vocês preencherem para cômputo das horas de atividade de extensão. Então, esse é um recado específico para os alunos do Mackenzie que nos acompanham aqui. Having said that, thank you so much. Once again, it's a great chance to have together Ascola, UIA, and Mackenzie once again for another conference. Virtually, Professora Juliana, but it's fine.
Great, thank you very much.
So, Professora Juliana, I think I will leave the floor for our speakers from the first panel. Okay.
Yes, I think we can do it. As I can see, Leda is online, and Leda is a really great researcher. I can tell you that. And Leda was really involved in this organization. So thank you, Leda, for giving your time for this project. Thank you so much for sharing your ideas with us. And Professor Vicente, thanks to Mackenzie again for facilitate this communication, because I can see they are sharing now these videos, and there's some friends around sending messages, and I'm really glad about it. I think this day will be a very important day for the researchers that shared their ideas in this book. So thank you, Midi, again, for inviting me to do this opening. And of course, it's an opportunity to share this moment with Vicente. Vicente, he is a friend, besides the fact that we are also working to Ascola, to Brazilian chapter from Ascola. And I'm very glad to see some young and also some important people getting involved in this project from the Women in Antitrust Network. So I wish you a great event, and I will be following the whole day, and I hope in the end we can also think about the next steps we can do, also with Ascola, Vicente, because we have several ideas to, make Antitrust, our competition law, more popular and more easy to the students in Brazil, because I don't know why some people still believes that it's not an easy it's not so easy to understand what we do and not so easy to understand what CADI do. So I think we still have an open floor to work with women in antitrust and also with the universities to make antitrust more popular in our country. So thank you so much again.
Juliana, and this kind of event that was promoted by WIA with the publishing of the book and with the support of Ascola also, and the broadcast live by Mackenzie TV, the whole conference will be found later at the YouTube. So it's a very important tool to widespread the culture of competition among our law and economic students. And when you said, I don't know why people think it's so difficult to understand competition, they believe, but it's not difficult. The problem is people don't study competition law. And this is something that is missing in our, I would say, from our law schools. I can't say about economic schools, okay? But in our law schools. And I'm happy that, for instance, Mackenzie has competition law as a very important subject that is taught by all the undergraduate students. And having said that, we have Professor Danilo Brum, that is one of the professors of competition law in our law school. So I think I said a lot. So thanks so much, everyone, and I wish you all a very fruitful event.
Well, thank you, Juliana, for the kind words. It's been a pleasure to be part of the Women in Antitrust Network together with María and all the other women that are joining us here. I am very happy to kick off this webinar with the first panel, in which we will discuss the changes brought by digital platforms and antitrust challenges. We will be joined by Viktoria, Sara, and Danilo. Viktoria will discuss algorithmic pricing and personalized prices. Viktoria is a professor of competition law at the Vienna University of Economics and Business and director of the Competition Law Hub. Sara will talk about regulatory distortion using Uber's entry decision in the US as an example to discuss possible distortionary effects of different types of regulation. Sara graduated from Purdue University with a Bachelor of Science in Math and Statistics in '87. She completed a Diploma of Advanced Study in Mathematical Statistics at Cambridge University in '88 and her PhD in Economics from MIT in '93. Since then, she has held a number of positions and currently serves as a senior lecturer in the MIT Department of Economics and the faculty director of the master programs in Data, Economic, and Development Policy at MIT. Danilo will join us and share his insights into these two subjects, particularly regarding the Brazilian context. Danilo holds a master's degree in corporate and business law and a bachelor degree in legal and social science from the University of Vale do Rio dos Sinos, and is a PhD student in political and economic law at Mackenzie Presbyterian University. He is also professor at the undergraduate course in law at Mackenzie Presbyterian University. My name is Leda. I hold a master's degree in economic law from the Universidade Federal da Paraíba, the Federal University of Paraíba, and a bachelor's degree in law from Getúlio Vargas Foundation. I am proudly part of the Women in Antitrust Network under the Academic Network Director. I have been working with antitrust law since 2009, and I will be moderating this panel. I will hand over to Viktoria, Sara, and Danilo. And at the end of the panel, we will open for questions of the audience via chat, the YouTube chat. So Viktoria, please, the floor is yours.
Excellent, many thanks. I'm just about to share my screen, so please just give me a second. Let's see. So you can see what I see, because that would be quite good. Okay. Okay, it says it can't display the content, which is a shame. Okay. Can you see my screen now? My slides?
Yes.
Yes.
Excellent. Great. Thank you. Great. So good morning to everybody in Brazil and good afternoon to everybody in Europe. It's a pleasure to be here and to be discussing the paper that I wrote for the Women in Antitrust book that's been mentioned already. And my chapter is an algorithmic pricing, a computational perspective on personalized prices. So, okay. My screen is not quite doing what I wanted to do. There we go. So what will I be talking about in the next 20 minutes or so? After a brief introduction, I'll talk about the uniform market price and what that actually means for us in competition law. And then asking, well, could algorithmic pricing be considered an abuse of market power under EU competition law? And here my perspective is, of course, that of an EU competition law academic, because this is where I am based. But the hope is, as this is an international webinar, that we will also gain some insights and have some discussion. Okay, am I back?
Yes, yes. Now I can understand.
Okay, great. Can you still see my slides because my internet broke down?
Yes, we can.
Yeah, okay. Good. So let's start with an introduction. Algorithmic pricing are pricing strategies where a computer program automatically sets the price. And usually, of course, this is done with the intention of maximizing the seller's profit. So in dynamic pricing, the algorithm adjusts the price based on, for example, current supply and demand. And algorithmic pricing can also be used to implement collusion on prices, so tacit or explicit. Algorithmic pricing can also be used for personalized pricing. So this is more than demand, or quite different actually from dynamic pricing. In personalized pricing, the seller offers the same good or service to different customers at different prices. And then those prices are not only determined by the seller's cost, but they're different depending on what the algorithm knows about you and what they've been able to find out about your willingness to pay. Now, we can distinguish different degrees of price discrimination. This was actually work done by Arthur Pigou in 1920, where he distinguished between first-degree price discrimination, which is more granular and tailors the price at an individual level, and second-degree price discrimination, where the price depends on the customer's choice, so whether I choose a train ticket for rush hour, which will be more expensive, or for a time where few people take the train, which will be cheaper. And then there's third-degree price discrimination as well, where price discrimination depends on groups of customers. So according to certain characteristics, so if you're a student or a female or a pensioner, you will pay a different price. So those are the different possibilities to think about price discrimination. So personalized pricing, in the words of the Competition and Markets Authority, the UK Competition Authority, personalized pricing is the practice where businesses use information that they either observe or that information that is volunteered or inferred or collected about an individual to set different prices to different consumers. And as I said again, this is based on what the business thinks that the consumers are willing to pay. So there is empirical evidence that consumers don't like personalized online prices that are set by algorithms based on location, gender, wealth, where you live, your software, hardware, your search behavior, and so on. But of course, just by consumers saying we don't like that, that does not tell us how this price discrimination should be treated under antitrust law. And there's also a question of, is algorithmic pricing different from pricing that you observe just in the real world? Because of course, we all know stories of a shopkeeper that sees a person coming in a Mercedes and will charge a higher price than if the customer comes in on a bicycle, right? So this is also personalized pricing based on the vehicle you've been driving. So is algorithmic pricing different or is it the same? Should we make a distinction between price discrimination based on algorithms or not? And here, I mean, we have some indications that algorithmic pricing is a different thing to deal with. In Europe, for instance, we have the Omnibus Directive of 2019, where companies now have to indicate to consumers when prices are personalized on the basis of automated decision-making. So this is a distinction from price discrimination on the basis of personal relationships. So leading on to antitrust considerations for algorithmic pricing, the question is, first of all, does this possibility of algorithmic pricing lead to disappearance of the uniform market price? Because that is something that we've been quite centered on in competition law. And does algorithmic pricing impede, or does it maybe even promote competition? So where do we stand on that? So this is what we'll get into now. So starting with the uniform market price, I mean, the uniform price is a bit of a myth because, of course, we know different pricing structures, right? So if I take a train, I'm not surprised when an elderly couple next to me or the students across the street have paid less for their ticket, or that there are price differences when I buy a ticket months in advance, or if I'm holder of a loyalty card, for instance. However, this is third-degree price discrimination because consumers are divided into rough groups. When I go to the supermarket, however, I very much expect that the elderly couple will, or the students, that they pay the same price for their bananas. But of course, we also know cases where we have loyalty cards that allow you to get a discount. So then maybe you expect an individualized discount. And that would then be price discrimination of a first degree because it targets me as a buyer and gives me, for instance, maybe not for bananas, but maybe on my birthday, I will get 50% discount on a cake. So we can distinguish between the uniform market price, which has not existed since time immemorial either, and different forms of price discrimination. And personalized prices are primarily about first degree price discrimination, but we can also talk about third degree as well. So the uniform market price in competition law has often been a central element of our economized antitrust law. If you just think of the SNP test or hypothetical monopolist test, economists model a price increase of 5 to 10% above the current market price to see whether consumers then switch to another product or not. And we also know from the cellophane fallacy that this doesn't work if the price is already above the competitive level. However, the cellophane fallacy isn't the only problem here. This also does not work as usual with dynamic or personalized prices either, because then it's no longer possible to determine this uniform price. We also know lots of price-based abuses of market power, about fidelity rebates, predatory pricing, excessive prices, selective price cuts, margin squeeze. And so those are also very much focused on the uniform market price, of course. And we also know that effects on price are often a yardstick for many antitrust violations in general. So this erosion of the uniform market price through algorithmic pricing is something that we need to consider if this practice becomes more widespread. And I think right now we're only at the beginning of it. So moving to the question, is algorithmic pricing an abuse of dominance in the terminology of EU competition law? What kind of animal is this? So to analyze this, what I did is go back to the criteria that we have under Article 102 of the TFEU, that's the Treaty on the Functioning of the European Union, so our main competition law provision on abuse of dominance in the European Union. And what we need to find, if we want to say there's an abuse of dominance, is we need a relevant market on which the company has a dominant position, and then we need an abuse of that dominant position. And no justification. So if we go back to those criteria, it's actually quite interesting to see what we can get out of algorithmic price discrimination. So the first thing is we need to find a dominant position on the relevant market. And then this directly leads to the first really relevant question. What is the product market in this type of scenario? So we can go back to the new EU market definition notice, which was just published in February this year, which says that if a company distinguishes and discriminates successfully amongst consumers, then perhaps the relevant market needs to be as narrow as the individual consumer. So you can interpret that into paragraph 88 if you want to go and have a look. So the question then is, okay, if that market is so small, then lots of companies, if they successfully engage in price discrimination, they might have a higher responsibility under Article 102 of the TFEU. Then there's also some interesting input if you think about gender discrimination that leads to price discrimination. In the OECD Gender Inclusive Competition Toolkit. And as this is an event of the Women in Antitrust collaboration, I thought this would actually be a very good point to make. It was not out yet when I wrote my paper, so I included here for the first time. So what does the OECD kit tell us? It says, well, it can be an issue of the relevant market to look at factors on the supply side and the demand side that impact gender. So you would look at things like, what are the attributes on the supply side? You would look at things like, what are the attributes of the product, color, feature, size, how does the product marketing work, the packaging, and so on. What are the product sales channels? On the demand side, you would look at factors like, what is the majority of consumers? What gender are they of? What is the typical behavior of consumers, and how does this have an impact? And then perhaps also think about what this means for the relevant market, if it should be narrowed down by gender, for example, which can also lead to a high responsibility for companies not to abuse their market power in that relevant market. So the next criterion, once we have a relevant market, and this is still open for debate actually, but the next criterion then is what about the dominant position on the relevant market. So what are factors for market power in those markets? Could it be that simply being able to assert individualized, personalized prices based on algorithms that observe the willingness to pay, could that in itself also speak to a company having market power? And there have been some voices in the literature on that. So once you have established a relevant market and you found dominance thereon, you need to ask, well, what about the abuse? Is there an abuse of market power if there is algorithmic pricing? And of course, we have to remember that the general principle is that companies are free to set their prices, right? But they are not allowed to exploit the market. They're not allowed to exclude competitors. And discrimination is also one of the types of abuses we have under EU competition law. So if you go to Article 102 of the Treaty on the Functioning of the European Union, you will find several aspects that could be used to look at algorithmic pricing. So the first one is excessive prices in litera A. And the second is literacy discrimination. And you also have the general clause, of course. So I'll go through those three in turn. So the first, excessive prices. When could algorithmic pricing be seen as something that directly or indirectly imposes either an unfair purchase or selling price or another unfair trading condition on the other party? And so the first question is perhaps, are prices to end consumers covered at all? I would say yes, that is the case. And then the question is, well, when is a price unfair? And there's two ways to determine this. You can do a price cost analysis, and you can compare the price to other products. So of course, from a starting point, this is an analysis that needs to be done case by case, and competition authorities are reluctant to become price regulators. So we don't have a lot of case law in this area. But what does the case law that we have in the European Union tell us about this? And that's actually back from the 1970s. So there was not a lot of algorithmic price discrimination back then, but the case law can still be applied to modern day cases as well. So under the United Brands test from 1978, the question is there an excessive difference between the costs that are incurred by the company and the price that is actually charged? And if that is the case, is the price unfair in itself or when compared to competing products? So the United Brands test assumes that we can find a uniform market price. Otherwise, we would have to make every assessment for every individual end consumer. But we can also do something if we change this a tiny bit. The second question we can also ask, is the price unfair in itself, or perhaps when compared to the price charged to other customers or other groups of customers? So there's a possibility to amend this test when we look at algorithmic price discrimination and whether some customers are charged excessive prices. Another possibility, if we want to think about the possibility of algorithmic pricing as an abuse of dominance, is Article 102C, which is discriminating against trading parties. And what the treaty says here, that it's forbidden to apply dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage. So the first question is, who are other trading parties? And while in 2007, Pinar Ackman convincingly argued that customers must also be covered by Article 102C, more recent case law on this criterion is stricter. So discrimination against customers and not against other trading parties, we would have to solve it via the general clause, which I'll come to in a minute. So this 102C we can only use if it's really discrimination against trading parties, which of course is also a possibility. That's not final consumers, but other trading parties that are discriminated against through algorithmic pricing. And then the question is, what is the competitive disadvantage? So here the court in the Mio judgment of 2018 helped us understand this better, and it said that, for instance, price discrimination between trading parties in the downstream market must, for example, lead to a distortion of competition between them. And you don't need actual proof, but you need to analyze all the relevant circumstances of the individual case and look if there's an impact on costs, on profits, or other relevant interests. So this now leaves us with the general clause as a further possibility to see algorithmic pricing as a possible abuse of dominance. And here, I mean, Article 102 in the general clause just says any abuse of a dominant position shall be prohibited. So could discriminating between, and so in some cases against some final consumers, be a possible abusive behavior? And then we again get to the question, is there really a difference between algorithmic price discrimination? Is that something special? Or is it the same as a price discrimination that is based, for example, on a personal business relationship? So here there's also considerations of welfare that we have to take into account, because economists tell us that in fact price discrimination makes some customers better off, the ones that otherwise couldn't afford the product, and others are worse off, those that can have a higher willingness and possibility to pay. One thing that I found interesting that happened last year is the Meta Platforms and Bundeskartellamt judgment by the Court of Justice of the European Union that was delivered last July. And in that judgment, the court said something that I think could also be applied in the case of algorithmic discrimination. So what did the court say? The court said that the General Data Protection Regulation, which is our data protection law in the European Union, could be used as a vital clue if a company infringes the GDPR. This could be a vital clue that it also abuses its dominant position. And if you transfer that thinking to other laws, not only data protection, but for example, also non-discrimination laws, which we have in so many jurisdictions, luckily, then the question is, could the principle of non-discrimination and a company going against this principle of non-discrimination in its price setting, for example, also serve as a vital clue, as per the Meta judgment, to understand possible abuses of dominance? So this is something that, of course, is quite new and recent thinking, but it's a possibility that we should consider as well. So this closes my thoughts about could algorithmic pricing be considered abusive? Let me just set out some further considerations in relation to antitrust. So this discriminating against trading parties is not only prohibited under Article 102, but also under our Article 101 of the TFEU. So that's our rule on anti-competitive agreements. So this is something that might not only impact abuses of dominance, but in fact also anti-competitive agreements. Then in the EU merger regulation, we should also think about what do we take away from these insights for mergers. If we think of a merger between a digital platform, for example, and a company that has a lot of know-how in data analytics and algorithmic pricing and so on, whether here you need more intervention, or if that could be a remedy to impose not to have algorithmic pricing, if that's even something we want, because that's not settled, I would say. And finally, it's also interesting to observe the relationship between personalized pricing and possible collusion, because it's been shown that if there is a lot of data, you can use it to personalize prices. You can also use data to facilitate collusive behavior, but usually you don't have both at the same time, because if you don't have uniform prices, then it's much harder to collude, except of course if you share the same pricing algorithm, which is another possibility. So let me now conclude and come to an outlook. So as far as we can see, antitrust law has not yet challenged personalized pricing, at least not in the European Union, and it's not quite clear whether it will do so in the near future. But until then, we still have to think about what could be helpful for the antitrust analysis once those cases come along. And of course, it's important to do this also together with consumer protection law, which also has something to say on that, because individualized discounts are something that consumers value, but the question is what are the welfare effects and what impact does that have? And of course, one point, behavioral discrimination doesn't stop at personalized prices. So digital platforms can do much more with what they find out about us, also getting us to buy more or to make a purchase decision faster. Like if they say, oh, 5 users are looking at this product, but we only have 2 left, things like that. So it's more than just algorithmic pricing we should think about. It's also interesting to see that online and offline are increasingly merging. So we see that there's a possibility to use the information gathered online about users to also give them offline, so in-shop prices based on that. So this is something that we should also observe. And as always, competitional responses need to adapt to current developments. And if algorithmic pricing is something we observe increasingly, then this is also where we should look more. So with that, I conclude, and I'm looking forward to the discussion.
Thank you very much, Victoria, for your very clear explanation on the topic. I will now would like to hear from Sara on her paper regarding regulatory distortion.
Okay, let me see if I can share my screen. Hold on. Oh no. Hold on. So I'm not so familiar with this with this platform, and I'm having trouble figuring out how to share the screen that I want to. Oh, I see.
Oh.
I share my window, just the window. Okay. Can you see that now?
Yeah.
Yes.
Not in presenter mode yet.
Yes. Okay. So let me switch to that. Okay. Unfortunately, when I go to presenter mode, I can't see this. I can't see anyone else. But I think that's okay.
But if you prefer, Sara, you can just leave it as it were, or we can read it.
Let's see. I have two screens here, and it seems like I ought to be able to have it up on one screen and then have you guys on the other screen, but I'm not figuring out how to do it. Let's see. Okay, but you can still see my slides?
Yes.
Yes.
Okay.
Yes.
Would it be okay if I just presented in this mode then?
That's fine.
Okay.
Okay, great. Thank you very much. Thanks to the organizers, and I'm very happy to follow Victoria's really interesting talk about personalized pricing. But we'll pivot a bit for this talk, and I'm going to be talking about some work I've done with a colleague, Anil, on regulatory distortion, and what we can learn about regulatory distortion from Uber's entry decisions in the US. So as you may know, there's a very large literature on the sources and effects of regulation. It goes back many decades. And this literature is both theoretical and empirical, particularly in economics. But of course, regulation, we all know, is not a monolith. It can take on many different forms, even within the same regulatory framework for a particular industry. And that's something that the extant literature didn't always directly address. They sort of many papers would take sort of regulation as kind of an on or off proposition, as opposed to dealing with all of the myriad complexities of what a regulation might entail. And the regulatory environments for hackney services in the US are good examples of these complex frameworks. So hackney services sometimes have regulations governing geographical coverage. That's very common. The fares that can be charged, driver training, car maintenance, emissions, safety, operations, all kinds of things. And we want to exploit the existence of different frameworks across US cities and the actions of one particular firm, Uber, who was not subject to these regulations, to shed light on the possible distortionary effects of different types. So just to put what the work that Hal and I did in some kind of a context in the broader economic research, let me just briefly mention the 4 different styles of empirical research on regulation. We can think of sort of a more narrative type accounts as historical studies, where there's a narrative of the function or dysfunction of a particular market over time, and we sort of learn details of that market and evolution of the regulatory regime as a response. And there have been books written about particular markets in this vein. So Hodges, for instance, has a book on taxi cab regulation in the United States from 2007. There are studies that we might call event studies, where we take a particular market before and after regulation or deregulation, some event, and we compare the functioning of that market on various outcome measures. Cross-sectional studies use a different kind of variation. So here we'll study markets across sort of different locations, for instance, different cities, different states, different countries that differ in regulatory rules or enforcement to determine the regulation's effects. And here I mention a particular paper in pharmaceuticals by Margaret Kyle, who looks across different regulatory regimes in Europe to see the effect on entry of pharmaceutical products. And then finally, structural studies, where we use the infrastructure of theory, economic theory and equilibrium conditions to try to estimate the effects of a regulation. And this paper is going to be mostly in the third style. I have a little bit of the fourth style where I sort of exploit some theory. But it has two unusual features that I haven't seen elsewhere in the literature on regulation. One is that, as I said, the regulatory regimes are complicated, multidimensional, and varied, and we have a lot of variation across those different dimensions. And so we're going to have an unusual opportunity to comment on differential effects. And then the second thing that's a little bit novel about this paper is that we're using the actions of a firm that's not subject to the regulations to infer the effects on ones that are subject to the regulations. Okay, so that was sort of the standard motivation that I would give for this paper for an audience that was interested in regulation. But I want to pose the question, is there something special about regulation in the digital age? And I think that the answer is yes. So new players in industries are fueling regulatory arbitrage. And in fact, some of the markets, some of the most successful sort of new digital markets may exist primarily for the purpose of avoiding taxation and regulation. And so I list a number of examples here. Online retailers and sales tax. Glenn Ellison and I have some work on this. In the United States, for a long time, most online transactions were sales tax free. And so we sort of looked at the sort of incentives that gave, the effects that had, the incentives it gave. Airbnb and hotel regulations. There's been a lot of criticism of Airbnb and other online rental platforms. In part because one thing that they're perceived as benefiting from is the fact that they are not subject to the same regulations that hotels are. Same with Upwork and TaskRabbit regarding minimum wage and benefit regulations. And you can even say the same kind of thing about Bitcoin and other cryptocurrency, and the incentives that people have for taxation and avoidance and skirting monetary policy. So understanding regulatory distortion and the motives for regulatory avoidance could become increasingly important in sort of these digital industries, I would say. Okay, so in the next 15 to 20 minutes, I'm going to give you some facts and figures about ride-hailing services. I'm focusing mostly on Uber and the effects that they're having. I'm going to propose a stylized model of Uber's profits from entry into U.S. cities estimate the parameters of that based on their observed entry decisions and detailed measures of regulatory environments. And then I'm going to use the results to comment on the distortionary effect of various regulations on hackney services. Okay, so when we started this research, this was a few years ago, and I made up this slide for a previous talk that I had given. And instead of updating the slide with sort of more recent figures, I thought it would be interesting to keep the slide from several years ago and then in blue sort of give you some sense of how Uber has grown over the past several years. So it is a web-based ride-hailing service launched in March of 2009. As of January 2016, so this is only 7 years after it launched, it had entered 190 cities and regions in North America and almost as many outside of North America. In the US, it received fairly little regulatory and public resistance. But that hasn't been true internationally. It's received a lot of resistance in many other locations. The estimated value of Uber, when I made this slide up, was 70 billion. It is now has a market cap of 144 billion. And this is so twice as high. And this is even given that it took a big hit during the pandemic. There were many people who sort of stopped, taking, stopped traveling, but also stopped taking shared transportation during the pandemic. But still, it rebounded and is now worth twice as much as it was a few years ago. In 2015, there were 160,000 active drivers in the US. Worldwide today, it claims to have 4.5 million drivers. So this is a huge growing operation. So we wanted to understand which aspects of the regulatory environment in different cities were distorting the market for hackney services. In other words, creating market opportunities for the entry of ride-hailing services. And so in order to do this, we put together a set of sort of a data set of the regulatory environment for hackney services in 250 US cities, essentially the 250 largest cities. And we collected data on as many different regulations as we could. And we ended up being able to collect pretty complete data on 19 different regulations and whether they existed in each city. This was not a simple data collection effort. Many man hours were spent searching websites, emailing, calling cities, etc. And despite this effort, there's still a number of missing values, which I'll talk about in a minute. And then in order to understand how Uber was responding to these different regulatory environments, we needed a record of when and if they entered into each of the cities. And we were able to do that through the magic of the Wayback Machine and archived versions of various websites that are publicly available. And so we went back to archived versions of Uber's website to record when and if they entered into each of these cities. So as I indicated before, hackney regulation in the US is a rich tapestry. We found, here's some of the regulations we found. Some cities require the posting of rates. That's not too unusual. Some limit the type and size of advertisements on taxi cabs. Some even have driver dress codes requiring long pants, for instance. There were many have prohibitions against picking up customers in other cities and bringing them back to the home city. There are regulations on fares. Sometimes there are limited licenses, often called medallions. There are also hidden barriers as well that we found, fuel efficiency and emission standards, and the list goes on and on. So let me just take a step back and say that we know that regulations can have a variety of intentions and effects. They might fix an intrinsic market failure. So for instance, there could be asymmetric information between the provider and the customer, and that could lead to sort of market failure or suboptimal market outcomes. And regulations can try to fix those. Sometimes fixing market failures due to blunted competition is the purpose of a regulation, perhaps because they're needed to fix a problem caused by other regulations. There can also be, sort of less benign reasons for regulations, and that could be rent seeking by certain market participants, or also known as regulatory capture. So nothing that I'm going to do today is assuming a specific view of the regulations and their intentions and effects. Perhaps, though, it's helpful to sort of have these different sort of notions in mind as I go through the results in a few minutes. Okay, so here are the regulations that we were able to consistently collect data on for our 250 city sample. And let's see. What we did is we coded them up so that they all varied between 0 and 1, where they were either dummy variables for the existence of the regulation. So for instance, if there was a fingerprint required for all drivers, then that got a 1, that was coded as a 1, and no fingerprint required was coded as a 0. And some of the regulations were really more, would be coded as continuous variables, and we recoded those so that 1 was the most restrictive and 0 was the least restrictive. So for instance, a maximum age of cars could vary across cities. And so we coded it up in that way. In some specifications, we assume that a regulation did not exist if we couldn't find evidence of it one way or the other, which we thought was not unreasonable. We did, as I said, a huge amount of boots on the ground kind of work to try to figure out what all of these regulations were. And sometimes you just couldn't find any evidence of a particular regulation existing in a particular city. And so in those cases, despite, sort of all of our efforts, we felt fairly comfortable to say that that regulation just didn't exist. We looked for it everywhere and we couldn't find it. So, okay. We categorize them into 3 types: safety, operations, and barriers to entry. And I'll show you some empirical results involving these categorizations, but also the individual regulations themselves. Okay. So I won't say much here about categorizing regulations. I think it's pretty self-explanatory. I'll just say that the safety regulations are ones that, again, without making strong statements about welfare, those are ones that, I would think most people would consider at least potentially welfare enhancing. We want to have safe cars driving us around. We want to have safe drivers driving us around, etc. The operations may be less clear. Some of those might be welfare enhancing and some of them might not be. These would include things like not allowing advertising on the side of a taxi cab, for instance. I'm not exactly sure how to think about that in terms of welfare. And then the barriers to entry are ones that that economists would imagine would be less likely welfare enhancing. These are more likely vehicles for regulatory capture. So taxi cabs keeping out potential competition. Okay, just a few summary statistics on the regulations. The pairwise correlations across categories were not particularly high. They're positive in all three pairs, but this gives you a sense that there was a lot of variation across cities in the types of regulations they adopted. It wasn't that they all adopted either high regulatory environments or low regulatory environments. There was quite a bit of variation. Then within categories, operations had the highest positive correlation and safety had the lowest positive correlation. Also to give you a sense of how cities, across cities, how overall regulatory regimes varied. There were 3 cities that had an average across the categories over 0.8. So this is the sort of most restrictive regulations. And those 3 cities were Chicago, Minneapolis, and Houston. They're all large, not the largest US cities, but all relatively large. And then there were lots of cities in our sample that had really quite low sort of measured regulatory stramgency. And here I list several of them, most of which, unless you live in the US, you probably haven't heard of, but they tend to be smaller cities. And I pulled a few out at random just to give you a sense of where different US cities might fall on our measure of regulatory stringency. Boston, which is my home city, is fairly high at over 0.6. Okay, Scranton, Pennsylvania, on the low side. Okay. Oh, I should say also that the data we found on regulations is a snapshot. Finding data on historical regulations was impossible. We basically, we put a tremendous amount of effort into finding the current regulations. That was not easy. A lot of anecdotal evidence suggested that there was a tremendous amount of stasis in these regulations. Some of them had not been revisited for decades. And so we're not particularly concerned about the fact that we just have this snapshot. Okay, so let me just go very quickly through the profit function and how we're thinking about sort of estimating the parameters in the profit function. So let's suppose that Uber's per period profit from entering a city is given by this equation. And it's going to be a function of city-specific characteristics. This includes things like whether there's how big the city is, how young the city is, how many cars are in the city, how much public transportation is in the city, etc. Okay, and then it's also going to depend on the regulatory environment. Okay. So given that this specification we have is monotonic in time, Uber is going to enter as soon as its profit is greater than 0 in a particular city, and it won't exit thereafter in our model. Okay, so we write the entry condition as follows. Okay. And so we can think of cities with more onerous regulations becoming profitable for Uber earlier. Okay, so maybe this bears repeating. The idea is that if a city has more onerous regulations, whether they're welfare enhancing or not, if they're more onerous, then that's going to present opportunities for Uber to profit because Uber's not going to be subject to those regulations. Okay, and so that's sort of the crux of that. That's our identifying assumption for coming up with these estimates. Okay, so this sort of explains what I just said. If the regulations are sufficiently distortionary, they create market opportunities for firms who are not subject to them. Okay, an example, let's suppose the imposing advertising bans on taxis was a binding constraint on taxi behavior. The taxis wanted to have advertising on the side of cars. They weren't allowed to. Uber's profit potential would be greater in the cities that imposed advertising bans if Uber allowed its drivers to advertise on their cars. Okay. So, and let me just emphasize, we're not poised to make strong welfare statements about the regulatory distortions. We'll say something a little speculative about welfare at the end. Okay. And why would a regulation that exists not be distortionary? So we will find empirically that some of the regulations don't seem to be distortionary at all. They don't enhance Uber's profits. And there could be a number of reasons. They might just not be binding anymore. An entrant not subject to a regulation might decide to self-impose it. So Uber had certain requirements of their drivers and their cars, so they were in some sense self-imposing some regulations. And yeah, there might be other reasons as well. Okay, so I will just skip ahead. That recall that this is the entry condition and this is what we're going to estimate. And so we get to the estimates, and let me walk you through what we learned from them. So we're in this set of results, we're going to use indexes, the barriers to entry, safety regulations, and operations regulations instead of the individual, the 19 individual regulations. And we have sort of two sets of results. One where we're just using the cities where we could, or we're just using the cities where we could definitively find that a regulation did or did not exist. And the second where when we could not find any evidence, we assumed that it did not exist. Okay, so in the first set, the regulatory variables don't enter the profit function in any significant way. In the second set, however, we're going to have where we'll have more observations, more variation to be able to identify the effects we're interested in. And we find that high barriers to entry and high levels of operations regulations both matter a lot. And in fact, they matter about as much in Uber's profits as multiplying the population by 2.6. Okay, so that's a huge magnitude. That's saying if you go from sort of a city that has no barriers to entry to a city that has barriers to entry, that city can be the less regulated city has to be 2.6 times as big as the more regulated city for Uber to be indifferent between entering those two. So it's a big effect. On the case of safety regulations, we find no evidence in any of the specifications that the ability to evade those regulations entered Uber's profit function in any significant way, which I think is good news for consumers. Suggests that either those regulations were not distortionary or that Uber self-imposed them. Okay. Just as a side note, we also included lots of other city-specific covariates, including, sort of all of these measures of other public transportation systems. And we find that the coefficients on the mass transit variables are all positive. Some are significant and some are not, but we thought that was interesting. We would have thought perhaps that Uber would be a substitute to them, but this at least suggests the possibility that Uber was a complement to the mass transit systems in existence. Okay, so one other set of results that I will mention quickly. The results you saw were all obtained using indexes that we constructed of the regulatory measures, but we have a large number of individual data on individual regulations, and also a number of demographic, structural, regulatory, or demographic and structural variables. And so we wanted to see if we could tease anything out of looking at a specification where all of these entered separately. Okay, and given the number of regulations and other covariates we have and the size of our sample, we had to use some kind of a specification choosing procedure like lasso. Okay. So here's the list of the demographic, structural, and regulatory variables in the order in which they contribute to the ability of our model to predict Uber entry. And just a couple of takeaways from this. The regulatory variables were almost entirely behind the demographic variables and the variables describing the city's existing transportation network. Okay, so first takeaway, the regulatory variables tended to be less important in Uber's decision to enter than the sort of other structural variables in a city. It's interesting to note that the most important regulatory variable, according to this criterion, was whether a city had a dictated fare. Okay, and this is suggestive to us of the possible profit opportunities inherent in Uber's surge pricing, because they were able to, sort of price adaptively and get customers that way. Okay, and that's just, Okay, so just a quick overview of the results. Each individual regulation is much less important in the determination of Uber's entry behavior than a sizable number of the city level demographics and structural variables. When we created these indexes, they enter significantly in the profit function in some specifications, but the safety index is never even marginally significant, meaning that we find no evidence that Uber gains a profit advantage by evading the safety regulations. And there is some evidence that Uber gains a profit advantage by evading regulations meant as barriers to entry and governing operations of Hackney services. And as I've said sort of throughout the talk, comments regarding welfare would be speculative. We can maybe say that our results suggest a little something in this direction. They tell us something about how distortionary these regulations are to the markets that they regulate. But the fact that the largest distortions seem to be generated by the regulations that we think are probably least likely to protect consumers and result in social welfare gains suggests that we might want to rethink the regulatory apparatus surrounding Hackney services in the US. So it's reassuring that the safety-related regulations don't seem to have been distortionary or led to profit opportunities for Uber. Okay, so with that, I will stop screen sharing. And okay, great.
Great, thank you very much, Sarah. I will now like to pass the floor to Danilo for him to share his insights with respect to the Brazilian perspective on these two different subjects pertaining to digital platforms.
Good morning, everyone. I'm very happy to be here today. I would like to start in saying thank you to the event organizer for inviting me, especially Professor Vicente, Juliana, Miriam, for their exceptional efforts to connect us here today this morning. I hope next time we can find us together here in São Paulo, or maybe in Paris or Vienna. But today I would like to thank you for my panel colleague, Professor Sara, Viktoria, and Leda. It's a privilege to be here and to share this moment with you and to learn about a lot with you, reading and listening you here today, this morning. Before I start, I have a message to pass to the undergraduate. We have some students watching here, and Professor Vicente asked me to pass a message to them. So 1 minute, please. I will speak in Portuguese because some students are here with us, and I will try to pass the messaging to they understand too. Então, aos alunos da graduação que estão ouvindo aqui em português, o professor Vicente pediu para deixar um recado que está no link do YouTube. Eu também vou compartilhar aqui na tela com vocês um QR Code para os alunos que estão precisando das horas complementares. Então, acessando esse link que eu acabei de compartilhar, vocês vão ter acesso... Espero que está aparecendo aí, Leda? Vocês vão conseguir preencher o formulário que o professor Vicente fez para ganhar as horas complementares. Eu vou deixar ele aqui uns minutinhos, porque eu não vou usar slide. And I'll back to speak in English. Now I will have no presentation, so I will. This QR code is here for the students to have access to the present list. My mission here is to connect these two excellent presentation with the Brazilian reality. It's a hard and very hard mission, but as a fellow, I provoke a discussion by Leda in the emails. I structured my speech in two parts, and the first one I will discuss the Professor Viktoria's paper about the algorithmic pricing and the impacts on competition law. And secondly, I will comment about the regulation distortion from the perspective of Uber entry here in Brazil too, with some studies that we also have here. In the first part, addressing about algorithmic pricing, we know that is a big challenge to talk about the algorithmic pricing, but it's crucial. Here, for example, at Mackenzie Presbyterian University, in the Competition Law Center that is coordinated by Professor Vicente, we have some studies about how the algorithmic pricing impacts, for example, the consumer law, the data protection, the competition law, and here we also have some kinds of labor law is also sometimes a subject that is impacted by the algorithmic pricing. The competition defense system that is the subject here today was here in Brazil and all over the world designed to combat human acts. But now, in this new economic era, knows the data-driven economy, like Professor Viktoria showed us, we have this algorithmic culture that plays a crucial role into define our life in defining price and our acts in the market. We say sometimes that that paradigm of the physical market in the street, for example, or the shopping center, are now the online hands. Now we don't have more that physical hands or the invisible hands like Adam Smith show us, but now we have online hand that is sometimes taking some decisions and make the prices or some other things that affects the consumer habits in especially in the online market, but also in the offline market, as Professor Viktoria showed us. In this way, here in Brazil, it's also a big problem. And as we discuss a lot of some particular questions about the opacity of the decision making, like Professor Viktoria bring us in her article. Sometimes it's very hard for us from law and I think for economics to understand how this technology make a decision and to understand if it's legal, it's illegal, and the effects that it brings to us in the market. And here in Brazil, we don't have any regulation in law. We don't have. I read in the Professor Viktoria articles that, for example, the European Union have now obligated the firms to show that the price is a decision making by algorithmic. We don't have to show an obligation to show how it makes the decision, but you have to tell the people that have some decision by algorithmic. Here in Brazil, we don't have any regulation. That is why some studies say it's completely legal here in Brazil to use this technology. It brings some benefits also, but we have to care with some especially the opacity of this technology in the impacts it could be in the competition market. That is why I would like Professor Viktoria to share two cases here in Brazil that we have a little discussion between the personality price or the algorithmic price, especially with consumer law. But I think it is the first time here in Brazil. I'm sure this is the first time we have discussed this case. But in the first one, in 2016, the Brazilian Antitrust Authority, the CAD, identified a cartel that used a software that was a software that was utilized by some companies that in the market of driver school to facilitate the coordination of prices and some other conditions in this market. Despite that there is not a big discussion between how the algorithmic impact is in this case, we have a software utilized by a lot of competitions in the same market, a little seat here in the state of São Paulo, Santa Bárbara do Oeste. And the drivers school utilized the same software that coordinated the price. And the authority will analyze this case, and the firms and the individuals that use the software was filed here in Brazil. We have a second case that is from 2018 by the Consumer Protection Defense Department. That is a branch of the Minister of Justice here in Brazil. That is the Consumer Authority here in Brazil. That analyzed a case of the firm Decolar.com. That is a firm here in Brazil that is the biggest seller of the tourism agents online that sells hotels and tickets for travel, for example. And this firm used some strategies to firm the prices using the geo pricing and geo blocking. After some notice to the authority, they analyzed the case across the consumer law, not the competition law. And with the consumer law, the authority of analyzing the case understands that this practice of geo-pricing and geo-blocking in that case could be a discriminatory pricing against the same consumer in the same conditions, and filed the firm in a big penalty here in Brazil. And I have noticed too that the public prosecutor in Rio de Janeiro, here in Brazil, filed 2 lawsuits with filed Decolar.com and another computer in this market that is Hotel Urbano. Sorry for Portuguese in this part because it's the name of the firm. And these lawsuits are not filed at this moment, as I know, but we have these 3 cases in consumer law disputing geo-blocking and geo-pricing here with the scenarios of consumer law, not especially competition, but consumer. The topic is very interesting. The presentation of Professor Viktoria is very clear and brings us with a lot of interesting positions to study here in Brazil too. But one point that sometimes we also discuss here is how to regulate this problem, how to resolve this problem. Could we do nothing and bring the markets out self-regulation, or can we make something? And here, for example, as we are in Ascola, we have some studies, for example, from Professor Eduardo Gaban, Professor Vinicius Klein, Professor Juliana Oliveira, an article that's, that we use a lot here in Brazil that suggests some strategy that is called competition compliance by design. And a strategy that maybe we should use compliance programs to address this problem, fix intern in the firm. In this moment that we don't have any regulation or some cases that could be that could bring more, how can I say, safety for the firm in this scenario of no regulation. It's a very interesting proposal. But it's always hard to say how is the best form to regulate this problem, to solve this problem. And we hope the next AVEX we can talk more about this because we believe it's a great problem and not a future problem but a present problem. In my second point, too, Professor Sara bring us a very interesting with a methodology that is very hard for us from the law, with a lot of numbers, but it's essentially because I forget to talk about some Professor Viktoria word that she said, we don't know, we don't have evidence, for example, if for consumer it's good or not, they like or not some practices of algorithmic preferring prices. For example, in this case of Brazil, the Decolar.com case, it is a great argument that was not discussed in this case. No? What I would like to say is, do you have some evidence here in Brazil that this practice was, in fact, bad for consumers? We don't have evidences in that case. It was a simple case, very simple, but it's some things that sometimes bring to think about it. Who says it's good, it's not good? We need to work more with evidence, and when we are together with you, professors from economics, with data analysis, it is very rich for us, because sometimes we from the law forget the numbers, forget to talk the reality, and stay in the world of words. Professor Sara, in your article, it's very interesting to observe There we have some similar study here in Brazil, conducted by also the Antitrust Authority here, the Department of Economics Studies of the Antitrust Authority. We have two studies. The first one was in the beginning of the Uber activities here in Brazil, I think 2015, 2014. That was a chaos here in Brazil because a new technology, nobody knows how to work. How can we regulate? Everybody wants to regulate. Some people say, no, it's not, you don't have to regulate. And the authority bring us with a study saying that is a different market between, as you say in your article, between the taxi and the Uber. And this, it was very important here in Brazil to calm down the authorities, to do not regulate in that moment a lot of regulation that could eventually stop the Uber here in the beginning. It was very important for us. But in 2018, a new study comes to understand how was the effects after the beginning of the activities, the impacts that Uber causes in the market of taxi driver. This study was with some data. The professor that assigned the study is Guilherme Rezende. He was the economic chief here of the authority here in Brazil, the Antitrust Authority here in Brazil. And he studied data of 519 cities here in Brazil. We have a lot of cities here. And similar of your study, and he concludes some things similar to your study. It's very interesting to see both studies together. First one, he also have concluded that some regulation of safety guard did not impact the Uber activities, but he found a lot of trying regulation of creating a barrier of entry for Uber, and some barriers that also is not good for the taxi driver. And as a policy suggestion, he suggested in that study that when the authorities start to regulate this new technology, they would pay attention to do not create more barrier to enter for the Uber, but also for the taxi driver. He suggested, for example, that you need to start to debate the regulation of the taxi driver to have more competition in this market. Despite he concluded that we have two markets, he concluded that also for increasing this market, especially for taxi driver, we need to remove some regulation of barrier to enter. Another interesting thing here in Brazil, we have some difficulties with, the firms have difficulties with labor regulation. Here in Brazil, we have severe labor regulation for some firms. And as you said, the new technology always try to figure out the regulation of the labor here in Brazil. For example, the driver here is not a regular worker from the labor law here in Brazil. He is an autonomous driver that do not respond to the labor law. But this year here in Brazil, the president of the Republic presented a bill to our legislative trying to regulate the worker relationship between the driver and the platform. this bill, this project of law, is trying to create some minimal salary and some minimal hours to a maximal hours for workers in this scenario of driving in Uber economy. It's very interesting to see here that this creation, we understand the preoccupation with the workers' rights, but it's interesting to see with your study and with Professor Guilherme's study here in Brazil that some of this regulation of work can improve more barriers to enter for some new technologies that will spend much more with work costs, but also some barriers to new drivers in this market. Because sometimes if you think a driver that would not spend so much time driving, but sometimes 1 hour, 2 hours between his home and his work, it could be not maybe some seniors more effective to exist. That is why it's interesting to see that maybe we will discuss a lot this project in our legislative. I think it will not be here in this year. We have to discuss a lot here in academy too. We are making some studies to collaborate with the legislative of the impacts of this new law. But it's very interesting to see that maybe this project could not be more tangible to what academics come to say in your study, in Professor Guilherme's study, and a lot of people that sometimes show some preoccupations with regulation that create more barriers to enter and more costs in this market. Well, too many questions and provocation. This topic is that I would like. Was very wonderful to listen, Professor Sara, Professor Viktoria, and to talk with you and to observe that the preoccupations that you have in USA and in Europe is similar that we have here in Brazil. And we hope this is it be only the first time that we can change some words about these topics that have a lot of things to discuss. So to not pass my time, Leda, I would like to give you the word to extend the questions of the public. Thank you.
Thank you very much, Danilo. Perhaps if we could just remove the QR code from the screen, please. I would now like to open for questions of our audience, but while they're getting their engines started, I wanted to kick off with a question to Viktoria. Well, I'm a huge fan of the subject of personalized prices, and whenever I discuss personalized prices, I usually get one of these two extreme reactions. So either are people like appalled by the idea of having their willingness to pay measured, and they strongly feel that this is a absurd violation of their privacy rights and an extreme abusive behavior from companies. Or either they act as if that's not really that big of a deal, something like, well, some form of personalized pricing has always been present, and it would almost be like it is what it is. So and I myself must confess that I struggle to find my place within these two extremes. I recently read a book from Nick Cernicek, which is called Platform Capitalism. And I found an intriguing remark which made me think, and I would like to read. He says something like this: demanding privacy from surveillance capitalists or lobbying for an end to commercial surveillance on the internet is like asking Henry Ford to make each Model T by hand. Calls for privacy means how the suppression of privacy is at the heart of this business model. So my question is, what are your thoughts on this? Has this privacy ship already sailed in the context of digital platforms? Should we accept that in order for us to live in this world, in this digital world, we will give up a margin, a portion of our privacy rights? Do you think that personalized prices should be considered either by antitrust, by consumer, or by privacy authorities as illegal per se? And here, please, Danilo, please feel free to jump in and comment on the Brazilian aspects as well.
So thank you, Leda, for that quite provocative question. Before I get into it, let me just say thank you to Danilo for your really thoughtful remarks. I think there's so much in there that we could discuss. I think we're slowly running out of time, but just very briefly, if you're interested in those kinds of cases, in Europe, we also had a 2016 case, the Eteros case, that I didn't mention today because it was an Article 101, so our anti-competitive agreements provision, not Article 102, abusive dominance, but they're also travel agencies use the same software to set prices and that capped certain discounts. So we do have some movement there as well. And on blocking geo pricing, I mean, EU law is very sensitive to that because it jeopardizes our EU single market. So I think there we're more really careful about those cases, whereas personalized pricing, we haven't seen cases there yet. And then your final question, how to resolve the issue, I think that's the hard one. And that probably brings me back to Leda's question. So obviously, there's lots of views on personalized pricing because we all have at least the inkling that we've been subject to personalized pricing, algorithmic pricing before. And many feel uncomfortable, like you say, and others say, well, it's always been that way, that's the way it is. But the way I see it, obviously, from a competitional perspective is, what does that do to consumers? What kind of welfare do we want to promote? And then we're back to the economic question of what does algorithmic pricing do? Because it does also broaden the market for those that otherwise couldn't afford certain goods or services. So I think there has to be a discussion here how we want to let technology interfere with our purchase decisions. And here I'd like to link back to what the European Commissioner for Competition, Margrethe Vestager, said once. We shouldn't let technology, decide what is best for us. We should decide what technology should do, and then we have to shape the legal framework accordingly. And I think we're at this inflection point where we can still do that. I don't think the ship has sailed. I think there's always something the law can do.
Great, thank you, Viktoria. Sara, you wrote a very interesting paper aimed at investigating possible distortionary effects of different types of regulation, right? Using Uber as a case study, in which you aim to investigate whether a city's regulatory environment had an effect on Uber's entry timing, right? On the timing of Uber's entry in each city. And you found that regulations you classified as barriers to entry did in fact result in market distortion. And you also identified that those barriers to entry regulations apparently did not seem to have any justification other than just impairing the entry of new providers. And then you suggest a possible regulatory capture story using regulation to protect monopoly power and capture rents. So indeed, here in Brazil, we did face a strong movement, a reaction from the taxi drivers, even though the population was very pro Uber, right? So after Uber's entry in Brazil, prices fell drastically, and this indeed leaves us to think if regulation is the only answer, right, to market failure, or whether competition also plays an important role. So my question to you is, to what extent do you believe the antitrust authorities should intervene, either investigating or through competition advocacy in scenarios of possible inefficient and unnecessary regulation?
Thanks very much, Leda, for that really interesting question. I think it's a fantastic question, and I can speak mostly to the U.S. context. That's what I know best. And as you know, in the U.S., there are sort of very strict constraints on what the federal regulatory authorities can do, can dictate at the local level, that states and cities, sort of about the regulatory regimes that they impose. And so there's a very limited amount they could do. As you suggest, maybe they could have kind of informational roles, advocacy roles, say, we have done some studies and we found that a regulatory regime like this might be best practice and might, sort of result in the highest consumer welfare. And this is what we could suggest. But their hands are going to be tied beyond that. I will say that there's one exception that U.S. Constitution gives us, and that's the Interstate Commerce Clause, which allows the federal government to decide on regulations that affect commerce across state boundaries. And so, for instance, this, it's been used in many different circumstances, but I will say that one place in particular where it seems like there could be a lot of advantage to invoking the Interstate Commerce Clause would be in sort of transportation networks. And by transportation networks, I mean like larger transportation networks that span various states. And, we've seen lots of cases when states and localities try to in the United States, when states and localities try to cooperate towards building some kind of longer distance transportation network, sort of the morass of different regulatory regimes can really get in the way. And that's a place where the U.S. government could perhaps take a more, activist role, I would say. Great, thanks.
Great, thank you very much, Sara and Viktoria, for your words. With this, I conclude our first panel. It's been a pleasure to hear you and also Professor Danilo. And now I'd like to pass the word to the second panel, María, and our panelists as well. So hope you can still join us and like the rest of our webinar. Thank you very much.
Thank
Bye-bye.
you.
Bye.
Obrigada.
Thank you very much, Leda, and congratulations on such a rich discussion on the first panel. And hello, everyone, and please be welcome to our second panel of today's webinar, in which we will discuss a cross-disciplinary approach to antitrust law. I'm María Rodriguez, and I'm honored to moderate this panel and to learn from our very special guest speakers, Athina Van Melkebeke, María José Henríquez, and Vinicius Klein. Let me introduce them to you. Athina Van Melkebeke is a partner in the Antitrust and Foreign Investments team at Kirkland & Ellis, based in London. She holds a Master's of Law degree from Ghent University and an LLM degree from the University of Chicago. She has practiced in Brussels, Washington, D.C., and London, and has been involved in matters before the European Commission, the U.S. Department of Justice, as well as various national competition authorities. Athina has also been involved in several of the first foreign subsidies reviews in the EU. María José Henríquez is a partner and head of the Antitrust and Compliance Practice at Morales & Bessa Abogados. She graduated in law at Universidad Chile. She holds an LLM degree from New York University in Trade Regulation Antitrust and a diploma in Competition and Regulation from Universidad de Chile Business School. María José headed the anti-cartel division at Fiscalía Nacional Económica between the years of 2012 and 2016. She's also a member of Red Pro Competencia, a network of female antitrust lawyers and economists from Chile. Vinicius Klein is a professor of law and economics at the Federal University of Paraná, where he teaches courses in law and economics, competition law, and regulation. He also works as a state solicitor in the Solicitor General Office of Paraná State. Vinicius holds a Master of Law degree in competition law from the same university and PhD degrees in economic development, also from Federal University of Paraná, and in civil law from the State University of Rio de Janeiro. Welcome, Athina, María, José, and Vinicius. Thank you so much for joining us today and for contributing with WEA's projects. And to start our discussion, I'd like to ask María José to talk about her paper on the fee regulation, the operation of payment cards in Chile, that is part of WEA's international book. Thank you.
Thank you, Maíra. I have my notes here. So first, I wanted to thank you and WEA for the opportunity to collaborate for the publication of the book. And thank especially to my co-author, she's Carolina Bawlitza, with who I share a common past as part of Fiscalía Nacional Económica, or FNE, in Chile. So the idea of our paper was to present a case in which antitrust laws may have been used for issues for which they are not necessarily well fitted. We asked ourselves why, in the case of payment cards in Chile, payment cards being credit and debit, basically, the antitrust agencies have been facing certain opposition in communicating its concerns and in finding and proposing adequate remedies for the risks detected in the market so far. Our hypothesis with Carolina was that the antitrust agencies had somehow deviated from its main goals by attempting, for example, to regulate prices or even take the place of the sectoral regulators, such as the central bank, when struggling to solve some of the issues being identified in this market. We found that the antitrust agencies, both the Competition Tribunal, or TDLC, for its name in Spanish, the Tribunal para la Defensa de la Libre Competencia, I will refer to it as Competition Tribunal, it's easier, and the FNE, the Fiscalía Nacional Económica, and even the Supreme Court appeared to be highly motivated by trying to change the payments by card industry in Chile, suggesting changes that range from regulations to from new regulations to even technological ways to operate in the market. So if an industry shift would happen, it would be in part thanks to their intervention. Certainly, this is not the first and only case of antitrust agencies attempting to explore beyond the limits of what has been for some time now understood as one of the goals of antitrust laws, the consumer welfare standard. In our paper, we quote an interesting article by Tirol about socially responsible agencies, which cautions against taking on another task by antitrust agencies. And also Jorge Padilla has a really interesting piece published in 2022 that considers that abandoning the consumer welfare standard could present risk. But however, as we analyze how the FNE, the Fiscalía Nacional Económica, and the Competition Tribunal had acted vis-a-vis the issue presented to them, we found that even though at some point some of the propositions of the FNE and the Competition Tribunal may have been considered audacious, such as suggesting specific figures for the regulation of the price, of the cost of operating credit and debit cards, at the end of the day, it appeared that, at least more recently, FNE's actions are, in fact, ultimately motivated by the consumer welfare standard. After carefully studying these many cases, and we're talking about cases filed in the period of almost 10 years about antitrust, constitutional actions, civil litigation, a lot of cases dealing with this market, we found that the ones presented before antitrust authorities regarding the operation of the payments card market in general, the issue at hand, in our view, is that antitrust authorities sometimes lack adequate tools to address the issues on their own, especially in densely regulated and rapidly changing markets. Also, in many cases, there may be a contradiction between consumer welfare standards, and this is something that's been observed in many other cases and industries, a contradiction between consumer welfare standards and other goals pursued, especially by sectorial regulators, which I will touch on later. Finally, the antitrust agencies, and this is something we observed during these years, have been somehow unsuccessful in communicating to these sectoral regulators the importance of considering competition law standards in their decisions. Or put it another way, the regulators have been reluctant to consider them. As to the case itself, and I would try to simplify because this is in itself a very complicated case in a complicated and difficult market. And there are a lot of cases, so I will try to simplify the story. And if you have questions, of course, you can take a look to the paper. We analyzed the case of Transbank as a card operator and merchant acquirer. In Chile, unlike other jurisdictions, most of the world, what happened in the early 90s is that the commercial banks, which are the main card issuers, started operating jointly through a joint venture, which they form and they call Transbank. Under this scheme, the role of the issuers, banks, the operator of the system, and the merchant acquirer is the entity in charge of negotiating terms with merchants, were integrated into Transbank. Transbank charged a merchant discount. Merchant discount is how the cost that the merchant pays for receiving payments with cards is called. And in this merchant discounts, all the cost associated with the system, meaning the cost that were supposed to be charged by the banks, known as the interchange fee, or the cost usually charged by card brands, Master and Visa, are included or are implicit in this merchant discount. And just to try to clarify this scheme, let me try to show you briefly how this is very roughly how this operated. I don't know if you're looking at my screen or not. Yes? Okay, thank you. So Transbank in Chile would be the issuer or its role, or it would act as the issuer, the acquirer, the operator, and charge merchant discount, which is the price of the goods or services that you buy minus merchant discount. Whereas in the rest of the world, the system looks something like that. And the operator is different than the acquirer, is different than the issuer, and they all charge their fees independently. Just very briefly, this is a complicated market, so but this is how Chile looked, and this is mostly how the rest of the world look. Okay, so and this started, as I said, Transbank started operating in the early 90s. And early 2000, there were some concerns that were raised at the level of antitrust authorities. In 2005, the former antitrust commissions, at the time there was no competition tribunal, the law was different, but at the time the former antitrust commission that existed in Chile declared that Transbank had abused its dominant position in the determination of the merchant discount. This is the price that they charge to merchants. And in 2006, Transbank agreed to a self-regulation plan which fixed this merchant discount. So we had a monopolist which is a joint venture for the bank, which is the only operator in the market, but the solution that antitrust authorities found was fixing or accepting a self-regulation plan. However, over time, the adequacy of Transbank fees to antitrust law was questioned again and many times again. Most notably, one of the milestones is a 2014 case in which the competition tribunal opened a non-contentious case. In Chile, the competition tribunal has both jurisdiction, whereas it has also, it can recommend amendments to law and regulations, and it can issue general instructions to the market. So in this context, in 2014, the competition tribunal opened a proceeding, and with an active participation of the FNE as well, both as competition authorities, the competition tribunal reached a decision in which recommended basically a complete overhaul of the industry, separating the roles of the issuer, the operator, the merchant acquirer, and other various recommendations. So I would say that's a milestone because it's an evidence that the antitrust authorities wanted to completely change and overhaul this industry, and went too far as far as proposing not only the separation of functions, which may have been reasonable, but also very detailed regulations, some of which were later considered by the central bank when it later issued regulators on the market. Continue with the case. Transbank fees have been always a case of controversy. So in 2019, for example, the self-regulation plan was declared anti-competitive of Transbank. And in 2020, again, another case, Transbank requested the approval of a new self-regulation plan and said that it had, assuming that they were moving to the new model, which all the functions from the issuer, from the operator to the merchant, merchant acquirer were separated. So Transbank this time asked whether the fees that they were going to charge for only being the merchant acquirer were okay. The Supreme Court declared that no, that this new tariff system of Transbank was anti-competitive, mainly because of the existence of volume discounts and also because some merchants were paying more than before. So before we had a monopolist that assumed all the functions in the operation of cards, being a joint venture of commercial banks. And then this Transbank terminated the agreements with the banks and decided to only operate as a merchant acquirer. Supposedly there was going to be a better system, and some merchants was still paying more for that. So they Supreme Court declared the prices anti-competitive. But what's more notably is that at the time, and this has to do with the issue of the paper, is that the Supreme Court declared that it was, quote unquote, the corresponding administrative agency and not the Supreme Court, the one called upon to regulate the payment system and determine prices. In other words, the Supreme Court, in its capacity as competition authority, exercising its duties of review of the Competition Tribunal's decision, and in connection to a consultation filed by Transbank, clearly stated that it was not the one called upon to regulate the payment markets and fees. It did not, however, indicate which one is the quote-unquote administrative agency who was supposed to be in charge of that. And today, no agency has leaned forward to take on the task. But we think this decision, with Carolina, my co-author, this decision from the Supreme Court is evidence of the perceived inadequacy of antitrust law to solve issues that range from behavioral, such as abuse of dominance, excessive pricing, to structural, regarding how an industry is reshaped in times where technology moves faster than the definition and understanding of our antitrust institutions. Since then, the FNE, merchants, economic groups have filed a myriad of claims against Transbank's commissions, and Transbank has filed yet another consultation regarding yet another fee scheme. The cases are still ongoing. No resolution so far regarding this issue. Besides these cases, and in terms of the operation of the payments industry, the only relevant regulatory change has been a law regulating interchange fees, which are the fees that are charged by banks. This has been done in line with other jurisdictions, most notably Europe, in which they're also regulated. And in terms of how the market is working, there has been entrance at the merchant acquirer level, meaning competitors of Transbank, consisting of locally owned and international car operators who have requested operators' licenses. However, this entry has not been without challenges, mainly because of the inertia of an industry that for 30 years has been used to work with Transbank. And this is true both for banks, but also for consumers. However, and notwithstanding the changes, the small pace of changes that we have been observing after years of litigation, which is ongoing, the issue of the regulation of Transbank as a former monopolist and now at least a dominant player in the car payment system has or remains unsolved. So what are the most notable aspects of this complicated but interesting and unsolved case so far? First, that in our opinion, the antitrust authorities had a clear intention of modeling the market structure at some point. motivated by claims from companies that wanted to enter the market and couldn't, and other distortions such as high prices and low penetration of cards throughout the country. Though the issue is an antitrust issue in its core, meaning a joint venture between banks to create Transbank being a monopolist, and the effect both on prices and quality because of that. My impression is that the antitrust authorities believe that antitrust laws were sufficient to correct the structure of the market, when in fact the issue exceeded antitrust law and dealt with a larger and strategical market, which is key to the economy, meaning to any economy, the payment system in general. And as such, it required maybe a broader analysis, which needn't include regulators such as the central bank. The other thing we observed is that even when the industry moved to allow the entry of new competitors, the antitrust issue remained. But in this scenario, the FNE decided to center its action in Transbank fees level, meaning, or in other words, in consumer welfare standards, more than trying to reshape industry and suggest even technological standards. On the other hand, the regulators, the central bank and the CMF, which is the Securities Market Commission, or the Comisión para el Mercado Financiero in Spanish, which have the authority to issue regulations and to interpret those regulations and apply those regulations to the payments market, have repeatedly stated that they do not have the power to regulate prices or commissions, and that such regulations could impact other objectives, such as the stability of the payment markets, highlighting the importance of making sure that players in the market have an adequate financial health. Though they do not mention this in their opinions throughout these cases, what I think this means is that they prefer that the operators can charge enough high fees to merchants in order to avoid an interruption in the operation of credit and debit cards in the country. It is understandable because this risk is not purely hypothetical after a couple of very rough years for Transbank financially in the past. Finally, it appears that the quote-unquote administrative agency referred to by the Supreme Court in its 2022 decision, the agency to uphold the issue of Transbank and other operators' fees in the market, does not exist, or at least none of them, not the Antitrust, the Competition Tribunal, the FNE, the Central Bank, or the Securities Market Regulator, the CMF, recognize in their laws and statute the power to become this administrative agency. In this scenario, and considering that the sector regulators have different goals in mind, meaning the stability of the payments market and making sure no player defaults, risking such stability, we think the best option, Carolina and I, we think the best option for the antitrust agency is adhering strictly to the objective of safeguarding the consumer welfare standard, as has been done most recently by the FNE in some of these cases. A departure from that objective could put the agency in conflict with the regulators and also compromise the results of its intervention, especially in rapidly changing markets very influenced by technology. Although I understand this issue may be debatable, although after all, Transbank once had the antitrust clearance when its self-regulation plan was first approved in 2006 by the former antitrust authority. Then the question is, then why shouldn't also another antitrust authority be the one to solve the issue? That's a question that remains up in the air. And with that, I finish my brief presentation and will be happy to take questions.
Thank you very much, María José, and thank you for the presentation and for providing great insights on this complex scenario of the operation of payments cards market in Chile. I found really interesting the analysis that you and Carolina made in your article, and the risk of leaving markets, using the payment card markets as an example, in a blank space where regulator and competition law left an issue unsolved. And the coexistence between regulation and competition law always brings a lot of debate. And I would love if we could talk a little bit more about that with Athina and Vinicius when we open for discussions. But before that, I'd like to invite Athina to talk about her paper on the final implementing regulation of the EU foreign subsidies regime.
Thank you, Myra. And good afternoon, everybody. And many thanks to María for the opportunity to publish our paper in your book, and also for the invitation to be part of this panel today. It's a real pleasure to be here. So our paper, which was written by myself with two colleagues, Sally Evans and Thomas Wilson, it concerns one of the hot topics in EU regulatory enforcement at the moment, the foreign subsidies regulation. The foreign subsidies regulation, which I will refer to as the FSR in this presentation, covers M&A activity and corresponding screening requirements, as well as public procurement. The paper and my practice focuses on M&A and the mandatory notification requirements and ex officio investigations that have become a part of the FSR framework in Europe. I will cover today the implementing regulation as you previewed, Myra, because that's the topic of the paper that we submitted. But my presentation will reach slightly beyond this topic because since publication, the FSR regime has come online. So we have the benefit of some initial experiences with this regime, which I wanted to share with this group today. So the FSR entered into force on the 12th of January 2023, and it initially took effect on the 12th of July of 2023. And from that point in time, the European Commission had the possibility to open ex officio investigations into foreign subsidies, distorting the internal market in the EU. However, the first ex officio investigations were only started this spring, with the European Commission carrying out unannounced inspections at the premises of a company selling security equipment just very recently. This is hot off the press, published yesterday. And the reason is that the Commission has indications that this company selling security equipment has received or may have received foreign subsidies that could distort the internal market. Earlier this month, the Commission announced the launch of an investigation into Chinese wind turbine suppliers, and that was actually the first ex officio investigation under the new FSR. The FSR, however, also introduced another layer of mandatory notification obligations, so introducing a new level of mandatory and suspensory merger screening alongside the existing merger control regime and the many FDI regimes that we have all across Europe. The mandatory notification regime under the FSR started to apply from the 12th of October of 2023. So we have had the benefit now of several months of initial engagement with the Commission on those notifications. Before delving into the detail, I wanted to touch on the objective of the FSR. So with the FSR, the aim is to identify where subsidies from countries outside the EU may distort competition in the EU market, and to understand whether there's any positive effects from such subsidies that may outweigh any such negative effects, and if not, correct the negative effects through redressive measures. When does the FSR apply? And then I'm just talking again about the mandatory notification regime in the context of M&A. It only applies in case there is a change of control of a target business. So that includes change from sole to joint control, vice versa from joint to sole control, or a change in the controlling entity. And there are also two cumulative monetary thresholds. And I think the first one will show you that this is a regime that's intended to really only apply to targets that have a quite significant presence in Europe, because for a notification to be triggered, the target needs to generate 500 million euro of turnover per year in the EU or more. In addition to that, the parties need to have received foreign financial contributions exceeding 50 million euro in the last 3 years prior to conclusion of the agreement or the announcement of the transaction. And in order to assess this second threshold and to also complete the filing form if a notification obligation is triggered, transaction parties, of course, need to be able to identify which foreign financial contributions they have each received. The definition of foreign financial contributions has been subject to quite significant debate, and it's been clarified in the implementing regulation. Foreign means that it originates from either a public or a private entity whose actions can be attributed to a non-EU country. And a financial contribution covers a very broad range of contributions, including your classic subsidy, but also grants, loans, tax exemptions, in the private equity sphere, limited partner investments, and it also covers even ordinary course supply arrangements with any public sector providers, so with healthcare or education providers that are public. All foreign financial contributions received by the parties need to be taken into account for purposes of assessing whether the notification threshold of 50 million euro is met, even if disclosure requirements, and I will come on to that, are slightly more limited and there are some de minimis exemptions there. What does the FSR filing process involve? It does track quite significantly the process that we are all familiar with for merger control in the European Union. The European Union merger control system requires the notification of transactions that meet notification thresholds on a form that's called the Form CO. And under the FSR regime, there is a new form which is called the Form FSCO. Certain parts of that form are quite similar to the merger control form, but others introduce completely new information requirements and are, of course, focused on allowing the Commission to assess potentially distortive and positive effects of foreign financial contributions. So I think you can allocate different buckets of information requirements in that form. And I'll start with the easiest one. So basic information, which takes the form of a table covering very basic information such as contribution, purpose, granting entity, and amount by third country over the last 3 years. That needs to be reported for all foreign financial contributions, but there are certain exceptions. So first of all, there is a de minimis threshold for disclosure, such that any foreign financial contributions which are individually valued at less than 1 million euro per third country do not need to be disclosed. Then there is a second de minimis threshold, which provides that there is no reporting requirement if the foreign financial contributions from a particular third country in the aggregate do not exceed 45 million in the last 3 years. This additional floor of 45 million, however, does not apply to foreign financial contributions that are likely to distort competition in the internal market, and those likely distortive FFCs are listed specifically in the framework. There are also specific rules for private equity funds that allow to limit disclosure to the foreign financial contributions received by acquiring funds, subject to certain conditions being met. Then ordinary course purchase and supply arrangements, already mentioned it, that does fall within the definition of FFCs, but to the extent that they have been entered into on market terms with public bodies, they are also excluded from disclosure. Similarly, ordinary course deferrals of tax or social security contributions, including tax amnesties, tax holidays, carry forward of losses, they are not subject to disclosure. It's only when such tax reliefs are selective, so are focused, for example, on certain sectors, certain regions, certain types of companies, that they need to be reported in the form FSCO. Then coming on to the more detailed disclosure requirements, the form FSCO requires a detailed set of information about any foreign financial contribution that is likely to distort the internal market. And that's a closed list, which has been clearly defined, which includes, first of all, a foreign subsidy that directly facilitates a transaction. For obvious reasons, that's really the focus of the FSR in terms of M&A. Second, foreign subsidies that are granted to an ailing business that is likely to fail in the short or medium term. Third, unlimited guarantees for debts and liabilities. Fourth, export financing measures that are not in line with the OECD-supported export credits. And finally, foreign subsidies that enable a business to submit an unduly advantageous tender proposal. For transactions that involve likely distortive foreign financial contributions, the form FSCO also requires far-reaching information on the sale process for a given target. And that's, of course, very sensitive information. So this particular disclosure requirement was also the subject of significant debate. However, even after significant pushback from the legal community, as well as investors, the requirements include indicating the number of bidders that were involved in the transaction process, as well as levels of interest at each stage of that process and some corresponding document disclosure requirements. As you can imagine, that's often very sensitive information. So we would expect that this remains a hotly debated topic also during pre-notification in the context of specific cases. And finally, there is a section of the form that allows the transaction parties to present positive effects resulting from FFCs, which can then inform the European Commission's balancing exercise. There is a possibility to request waivers from disclosing some of this information during the pre-notification phase if information is not readily available or it's not, in the parties' view, necessary for the Commission's examination of the case. And while the possibility of requesting such waivers sets a constructive tone and is, of course, a parallel, again, with the EU merger control regime, initial practice and experience with the first cases has shown that in practice, the Commission is, at least at this stage, reluctant to provide waivers. The conditions are very strict and the waivers are only granted in exceptional circumstances. During its review, the Commission can also request additional information about any type of FFC, so whether it's likely distortive or not, in case it considers that information to be necessary for its assessment. And when it receives the form of FSCO, the Commission will assess all that information and work out whether there will be any negative effects of foreign subsidies involved and balance them against any positive effects invoked by the parties. If the negative effects outweigh the positive effects, redressive measures are available. And again, those will not be unfamiliar. These include structural remedies, including divestitures, behavioral remedies, but also possibly having to repay the subsidy received or in exceptional cases, prohibition. So what does all of this mean in practice? It means that there is another suspensory filing obligation. So confirmation needs to be obtained from the European Commission that it has finalized its investigation before a transaction can close. So unlike in merger control cases, no clearance decision is received at the end of phase one, but there is a letter that confirms that no in-depth investigation is launched, which then allows the parties to move on to closing. This has introduced a new element of conditionality in transaction documents. And of course, it also has a significant timing impact on deals in Europe. On the timing point, like in the EU merger control regime, there is a pre-notification phase in this process, and parties are strongly encouraged and in practice always do engage with the Commission before submitting a formal notification to give the case team the opportunity to raise questions and to also align on what's exactly disclosed in the notification before the formal review period starts. Based on our handling several of these first filings, the duration of pre-notification really varies. It can take from just a few weeks to several months, depending on the data readiness and completeness of the initial draft filing, as well as discussion around potential waivers. We would expect that this pre-notification ultimately, on average, becomes slightly longer because, of course, this is still a regime that is in development and become more established over time. Once the pre-notification period is complete, the formal review period starts, and like in EU merger control, the phase 1 review period is 25 working days. But unlike in EU merger control, this 25 working days cannot be cut short. So the Commission will always take up that full 25 working day period. And then at the end, if it decides not to open an in-depth investigation, confirm through a letter that it has not identified reasons to engage in such in-depth review. With that, I've come to the end of my presentation, but happy to take any questions.
Thank you very much, Athina, and thank you for the great presentation. The discussions on the intersection of competition law and foreign investments policies, which really brought the attention of the Antitrust Society in the early 2000s, has really re-emerged in the couple of years. And it's very interesting to understand how the EU has addressed that, even though it seems that the Commission has really broad powers to analyze such cases. And of course, how the debate on the need to find the balance between promoting foreign investments as the condition for free and fair competition and the need to provide legal protection against practices that distort competition, that is somehow mixed with the EU policy needs, how this debate is going to evolve in the future. So thank you very much for your contribution. And to continue our discussions, I'd like to invite Vinicius to comment and provide insights considering the Brazilian perspective.
Hello, thank you very much for the opportunity to speak with in this panel, and congratulations to Maria and Athina and their co-authors for the 2 excellent papers, and María for moderating the panel. It's 2 interesting papers with different topics, but they have some important discussions, I think, on remedies that can be a little treated jointly. The first case of the transbanks, it's very interesting. It's more close to the Brazilian reality. It's something that happens in several countries, as María has pointed, and in Brazil, I think we didn't have this scheme with 4 parties, as you showed it before. And one of the questions, I think, was that the discrimination of prices between different insurers of issues of bank issues, for instance, depending on the volume of credit you put in the system, and this was forbidden by the central bank, and you had authority.
Vinicius, I think we lost you for a second. Would you mind repeating?
Yes, sorry for the internet quality here. I'm in a hotel.
That's okay.
Internet is not so good. And so the issue was solved by the central bank. That is the financial regulator, not by CADE. The investigation was closed by CADE with the solution by forbidding discrimination of prices between types of bank insurers. And it was an interesting case. Also, I think I have to think about the effects that are very challenging to balance, because in one point of view, if the tariff is too low, you have an effect on the issues of the bank issues. If the tariff is too high, you have an effect on the merchants, and you have to balance these 2 effects in these 2 side markets. It's not easy to find like a price that is optimal, even for a competition agency. I think it's a very challenging task. And you have to think about also, I think, the competition between different technologies of payment system. Brazil has some different technologies, and I think maybe it's not a competition issue. Think about protecting credit cards market between other types of payments, other forms of payment with fintechs and new forms of payment innovation. You could have a challenge in the traditional credit card market, and they would like to understand or to ask, how do you think about that, María? If it's gonna be, it's gonna impact the decision if you have less usage of credit cards, and this can be a likely scenario in the future in Chile, maybe. And regarding the foreign subsidies, it's a challenging issue for me because it's very different from Brazil. It was a very good paper, but to discuss is not so easy. One of the things I was thinking about is how you conduct the effects analysis, because it's not a traditional antitrust analysis of effects. I think you probably don't think about consumer welfare in this analysis. Maybe you think about, as María said, think about if you're creating too much pressure for investments, or if you can think like the type of country you are dealing with, like a common example now, China is putting too much subsidies in a company, then it's going to be treated different from Chile maybe or Brazil, and this can trigger this. I don't know if accusation is a good word, like this idea that competition policy in European Union is becoming more an industrial policy tool, and it's going to be like a way of doing commercial war or something like that. Thank you very much for the opportunity.
María and Athina, would you like to address the Vinicius comments and questions?
Sure. Can I go first?
Yes, of course, Maria. Thank you.
Thank you, Vinicius, for your comment, and also addressing your question, Maíra, regarding this conflict between regulators and antitrust agencies. My feeling is that antitrust agencies in this issue have been kind of preaching in the desert. They have put an emphasis on prices. These prices are too high. It's causing some unwanted effects, and the regulators have said, basically, we are not going to be involved in that, and also said maybe good prices are good, high prices are good for the stability of the system, which for me personally is surprising, because high prices mean higher costs for merchants, mean higher prices for consumers, and this is a central bank we are talking about. So the effects on inflation there. So that's an opinion. Maybe if maybe a little bit of consumer welfare standard will be better for regulators. But that's a personal opinion. Meaning, it's okay to defend the operators of the system, but maybe part of the system is also the merchants and also consumers. So, but that's a personal opinion. And as to your comments, Vinicius, yes, there have been a lot of substantial issues of antitrust raised during these 20 years of litigation, one of them being price discrimination between merchants, specifically volume discounts. You know, if you make volume discounts, larger retail chains, for example, are going to have better, lower cost than your moms and pop store around the corner. So, and that itself is distorting or may distort competition. So you have a payments market that may distort other industries and relevant markets. So that has been raised. And as to your last point about non-traditional ways of payment, my feeling is after 20 years of litigation that we are going to fall behind. Whenever this issue is solved in one of the many cases open in the Supreme Court, Competition Tribunal, civil constitutional actions, which are still open, the market is going to be something else, something different. And my feeling is that we are going to be late, of course.
Thank you, Maria. Athina, would you like to address the other questions and comments?
Yeah, sure, Myra. I just wanted to pick up on your earlier point around coexistence of well, certain state regulation and competition law. Of course, you know, the new FSR regime has created yet another layer of regulatory screening alongside virtue control at the EU level and national competition authority level in Europe. I actually do believe that those can coexist. And they are complementary. So the foreign subsidies regime was established in order to address what was previously perceived as an enforcement gap, because subsidies granted by member states are, as you know, subject to close scrutiny under the state aid rules in the EU, whereas foreign financial contributions were going unchecked. And so what this regime does is it introduces a pre-screening mechanism to effectively review and address potentially distortive foreign subsidies that undermine the level playing field in the EU.
Thank you so much. Vinicius, would you like to comment something additional as regards the answers they gave to your comments as well?
One of the things I need to do, I think, is to share the QR code for the students. But
oh, okay.
Let me see if I can do this, because regarding the answers, this thing about being too late that María said, it's very interesting, because sometimes you can think about the idea that competition law just nowadays in digital markets, sometimes you think about, if you don't have good remedies, why you bother to do a competition intervention? And like, if the remedy is setting the prices, you're not promoting competition, because competition is not the idea. It's not the idea of someone saying prices. So what do they think about this idea that if you don't have good remedies, maybe you don't need to worry about doing competition intervention? And regarding Athina, the idea that I understand that state foreign subsidies, this is a complement also from state aid. When do you think the idea of making like a leveling playing field between outside companies and European companies is a competition, important competition goal, or it's like too much a regulatory goal, or doesn't matter?
Would you like us to react on your comments, Vinicius? I agree with you. I agree completely. Sometimes, and in the case we presented, at least I don't see the light at the end of the tunnel in some way. So I agree, but that if you don't have the tools to do it, why do it? I feel that the issue of transaction is special because it was in part created by antitrust authorities, so they do feel kind of responsible. And maybe there's no one else who has tools. The few they have decided to use it with not much results so far. I mean, we have to wait and see about that. But I agree with your comment.
And in response to your question on the foreign subsidies regime, I do think that a regime like the one that has been introduced is appropriate in order to secure that there is a level playing field, because it would seem to be quite unfair that internal subsidies within the EU are subject to significant scrutiny on the basis of practice that has been established for a long time, whereas we know that foreign subsidies are sometimes creating distortions in markets in Europe to the disadvantage of competitors who are trying to win business fairly. So the short answer to your question is yes, I do think that the challenge associated with creating this additional new regime, however, is to find the right balance between being open for business and ensuring that there is this level playing field, because as you'll have gauged from the paper and the presentation, the disclosure requirements are really significant, and the burden imposed on transaction parties is enormous. And so I think it's really important that enforcement practice develops in a pragmatic way. But I feel that so far discussions with case teams have been very open, and both sides recognize that collaboration is required in order to come up with a pragmatic regime that achieves its objectives without signaling that doing business in Europe has become overly complicated.
Thank you so much. I'd like to invite our audience to ask questions to our speakers. Vinicius, were you able to put the QR code? I don't think I see it. Can you please try to do that again?
Okay, I will try.
Yes, thank you. Now I see it. I don't see any questions so far, but I'd like to ask a few questions and trying to make a connection with the last thing that Athina said about the burden put on transactional parties as a result of the regime. So I would like to ask more broad questions to all of you about the biggest challenge of the connection, the coexistence between state regulation and antitrust, and particularly as regard the downside and the burden to the protection of free competition and to consumer welfare.
Well, I think that has been a discussion that will never stop. New markets, new technologies, new regulations, and then the conflict with antitrust law, competition regulation. It's old as competition law itself, I think. There has been a lot of cases in which, at least in Chile, the competition agencies have said sometimes there are bigger goals. There are sometimes some things are more important that the consumer welfare standards, especially in regulated markets and in markets dealing with services provided to people, public utilities, and such. And I think that has been a declaration that has been repeated in many cases that have been brought before competition authorities, which is in its essence. I don't think it's wrong. I think sometimes you have to overlook some antitrust considerations, for example, some transparency of certain information that we as antitrust practitioners think maybe that's not the more adequate in such a market. And but I do think that our authorities and authorities throughout the world should enter more into efforts of educating regulators and agencies in terms of considering a little bit these standards. These are important. looking more on a long range of time. Sometimes you're thinking about today, what happens with the regulation? Well, no regulation, no market, no industry is going to work if they're not efficient and productive players in the market. So how do we protect that long term? While I think that sometimes there are bigger objectives, and that's fair, I would like to see more advocacy on the side of the agencies in general.
Thank you very much, Maria. Athina, would you like to comment as well?
I think I've already kind of addressed the key perspectives from my side. I think, finding a balance is really the critical point to try to achieve. But totally agree with Maria. This is a long-standing, complex debate. Finding the balance will always be difficult, and it will remain subject to discussion for probably forever. But interested to hear Vinicius' thoughts on that as well from his perspective.
Like this idea of regulation and different goals and competition law, I think, as I said, balance is very hard, and finding the right balance depends on what's the most important part of the trade-off you wanna do it. And for this, you need to think about the methodology, and I think the concepts you're using are enough for that. And I think is a big question for antitrust. The concepts as consumer welfare things or concepts like that are enough for achieving the balance. For instance, if now we want to put more enhance innovation instead of as we did before, for instance, in payment markets, and if you want to give more value to innovation than in the past, how are we going to do it, and how is going to change the way we practice competition law? I think this is an important point. And I think when I made my last intervention and said like the question, for instance, about industrial policies, because we see in several countries, like for instance, United States, the idea that the idea of nationalism or national issues being very important in corporate law nowadays, and things like and in this question of digital markets, the idea of sovereignty and things like that are becoming back as for instance, innovation is coming with more emphasis on competition law. I think national issues are coming back in several discussions nowadays, and to find the balance is hard. And like this thing that in some country in Europe, the idea that state aid and law is I think if you compare it to other countries, it's very strict. Because European Union has this idea of this state aid law, but in Brazil, if you think about competition neutrality from state-owned enterprises, for instance, it's very flexible. Like nobody, I think, CADE doesn't analyze this, or the Brazilian Competition Authority does not take into account how much state-owned enterprise gets money from the Brazil government, from a state like a state where I live in, Paraná State, or things like that. And this idea that the level playing field must include foreign subsidies is not so natural, I think, some other countries of the world and some other parts of the world. And I understand competition neutrality in the OCDE, in several best practices international organizations, but I think it's still is, for me, it's still a little surprising, but not surprising, but it still is not so natural to think about European Union saying you cannot help your company with your money from your government, or for something like that. I don't know. Thank you.
I think Maria raised her hand. I don't know if you still want to comment.
No, sorry, I was a mistake, sorry.
No, that's fine. On that, I'd like to share, there's a very recent case in Brazil where the Brazilian Antitrust Authority was provoked by a company that asked whether it would be infringing competition law by complying to a regulation that, in the company's opinion, had anti-competitive effects. And so far, the Brazilian Antitrust Authority's way of dealing with it was to say that the company had to follow the regulation, and that if there was any anti-competitive issue regarding the regulation, it would act via policy together with the regulation. So not acting on a case-by-case basis, giving some kind of permission not to comply with regulation, but saying that antitrust authority and regulators should communicate more and trying to find better ways to regulate and not like having an anti-competitive effect from any regulation. So that is kind of an example of maybe a downside to consumers and maybe to the companies considering that potential anti-competitive effect. But it's interesting to see how this is going to evolve in the future. I don't know if my connection is bad. Are you guys listening to me? I'm sorry. I think I was frozen for a bit.
No,
oh, okay.
That's perfectly fine. And now that we have time, because I think we do have time at the, you and Vinicius have touched on some interesting topics. And I think we can mix it now that we have time with the other objectives that are being incorporated into antitrust law recently, mainly if you think of the US merger guidelines, the new ones, and other. So this discussion about the intersection of regulation and competition and how they do get along. Now we have to maybe mix it with the shifting in competition law objectives, because I was talking about consumer welfare standard, where that has been in place maybe for 10, 15 years, but before that it wasn't the case, and it was total welfare. And sometimes people said, okay, competition agencies are not the consumer protection agency, so we should think about total surplus. And before that, we were thinking about having unconcentrated markets and promoting initiative from startups and maybe small businesses. And nowadays, before the consumer welfare standard, we're also thinking about how how market power correlates with maybe political influence, economic influence at a higher level. So I think this issue of the intersection is going to be much more complicated than we are thinking about right now. We are talking also about some other objectives which are fairly new, very novel to competition law, though it was an issue of conversation back when I did my LLM back in 2010. The issue of, I don't know, should competition law think about effects on, I don't know, gender issues, environmental issues, and so on and so forth. Should that be also one of the goals of competition law, or should it be an issue, antitrust law, an issue of last resort, only pursuing conducts and effects on competition. So just because we have time and and we have been talking about these very deep topics, I think that today we are like in position in a time in which we're going to see great shift of what should be considered competition law objectives, and then that would mean that the relation with state regulation will also shift in terms of how we analyze that.
Thank you, Maria José, for the provoking insights. I remember not that long ago, I interviewed Professor Fox, and she was talking about the new Brandeis movement and how antitrust has taken a different turn in the US, particularly considering those other goals that are being targeted by antitrust law. And we can see, like in the merger guidelines that you mentioned, that even labor law and the effects of merger in the labor market are being considered. So far in Brazil, we still have not that much of a discussion on that, meaning that so far the antitrust authority has positioned itself in a way of not including such different goals as gender, etc., into their analysis. But I'm pretty sure they're going to be provoked to address some of these issues in the near future. So we're gonna see in practice how they're going to decide that, how they're going to consider the effects of other goals inside the traditional antitrust analysis. And of course, there's going to be discussion on whether they have the necessary tools to do that, because it's not easy to consider these kind of effects when the law does not foresee the tools to analyze and quantify damages and effects on different goals. So I don't know if Vinicius and Athina also have a comment on this provocation.
No, like I think this issue of new objectives and things like gender and labor law, they must be addressed in a way that we can have keep the level of predictability and legal certainty. And if you can have a way of achieving that, I think it's good for competition law.
I don't know. I know some professors that would disagree on this. Professor Hovenkamp, a great champion of anti-Brandeis and anti-structuralism, would say that we know the antitrust institutions, they have worked for a lot of time. It's all the same story once again. So I don't know. I don't know what, well, no one can predict what will happen, but I think it remains to be seen whether the introduction of new objectives and new scopes of analysis and new lenses are good, bad, or neutral in antitrust. I don't know.
Thank you so much.
One final comment from my perspective. I think, of course, there is also this, in particular around effects on employment, although I feel that the focus has not yet shifted onto this topic in the same way as it has in the US. one jurisdiction outside of the EU and the US that does stand out for me at the moment is South Africa, which has for a long time had a practice in securing that public interest isn't harmed, and more recently is actually improved through many activities, and the authority is known for actively requiring remedies showing that the public interest is improved through a transaction in every single case. So I think that stands in stark contrast to enforcement practice elsewhere, and it's often felt by transacting parties that that's not necessarily that shouldn't necessarily be part of an antitrust assessment, because such requirements are imposed also in transactions that do not give rise to any competition issues whatsoever. And insofar as other jurisdictions are concerned, there are, of course, already many other regimes that look after the public interest, not in the least the foreign direct investment screening mechanisms that have popped up all around Europe and beyond.
Thank you so much, Maria, Athina, and Vinicius. It has been a great discussion. We even tackled a little bit in other subjects, and that is a great thing to do, especially when we have the opportunity to talk with other practitioners from different jurisdictions. So thank you so much. And I'd like to thank you, of course, you for joining us and for participating in the book and to helping WIA promote its projects. It's really important for us. And we'd like to, of course, invite the audience to read the papers that have been discussed here today and all the other amazing papers and contributions to WIA's international book. We're going to take a break in our webinar now, and we're going to get back at 2 p.m. São Paulo time for our third panel that is going to discuss merger review involving digital platforms. So once again, thank you very much, Maria, Athina, and Vinicius for this amazing opportunity.
Thank you very much for the invitation. It was a pleasure to participate in the book and in this panel as well. Very nice meeting you, the rest of the panelists.
Likewise, very nice to meet you all, and thank you so much, María, for moderating this panel and for the invitation.
Thank you very much, and it's a great honor to be part of this panel with the two brilliant authors from two excellent papers, and I also would like to say it's a great effort initiative, the Women's in Antitrust, and whatever I can do to help, you can count on me, and thanks very much.
Thank you.
Thank you so much. Bye-bye. Thank you.
Bye-bye.
Bye.